That's sorry to the problem we have got. But today I keep the matrix, direct supposed to address it. Dialysis, some accommodation for today. With item number 29, because since my friends on the other side are not here, when the matter is called up, an accommodation to be for
Yes, Mr. Sandal is there.
Okay.
College service is the junior.
We heard it out, Mr.
Yes, I will it too.
Or yes, can you then you do one thing. To tell us a date. I think Mr. Dotto, you have a talk with Mr. Shanna. Tell us two tentative dates. Ask your junior.
But at 2 o'clock, your lordship.
Yes.
Your lordship is to pay
Mr. Dotto, sorry, that Rajiv Brahmo matter,
Yes.
fixed it on 28th. 28th we will be having. So we have kept it on 24th.
24.
Dr. Patra told me that he has already
urgent appeal. The appeal pertains to whether they complete the process of the Central School Service Commission. Petitioners are classified as a tainted candidate as per the Supreme Court judgments and the High Court judgments. However, what happened was in the High Court judgment, there are 4 categories of candidates who have been declared as the categories have been created. All candidates, waiver expired candidates, waiver blank waiver candidates, and out of panel candidates. Now, petitioners
the order passed.
yesterday, well, the order is not yet been uploaded. So that is
How can we get the uploaded copy, sir?
I am expecting today to be uploaded by the sometime.
But to leave granted, it will appear on Monday. Yes.
Copy may be served upon
You
that.
get the server copy first. Then you take my auditors.
A copy may be served upon us when we are appearing for the commission in this matter, in this appeal.
Yeah, Mr. Judge, then serve upon Mr. Rahul Singh. Yes, call the list.
Item number 1.
No, we were told that we don't have the determination to take up the matter. You are for the appellant. It was mentioned before. You mentioned it. You are appearing for whom? The appellant. কে মেনশন করেছিল এটা?
ছিল
Mr. Basu, therefore, it has been mentioned, but we have not mentioned.
Oh, I see. Appearing for whom? Holden Bush?
Mr. Bose is appearing on behalf of the writ petition.
Oh, I see. The appellant is the writ petitioner.
Appellant is the writ petitioner. No, I'm sorry. Appellant is the suit.
Then, madam, I cannot take up this matter. On personal ground of one of us,
The order has been challenged here. In that order,
on personal ground of one of us, ওনাদের appearance দিয়ে দিই। The matter stands The last part.
Item number 2,
and put the applicant. Beginning with chapter the book of Sahara, but he was not ready to the applications today. Any day matter either Friday or Monday, any day matter. This kind of because everything is accomplished. Only everything or can be permitted to find my. I have two applications.
Fighter though.
But it's similar to please item number 2 and 3 is the connected microorganisms.
You are for whom?
Two applications have been filed from the same.
Same
One by the agreed person, it take to effect, and another by the. Another application of the one.
I we don't need next day instruction.
sorry.
5 year
It's also possible. Only one request minute. We'll look at party has little
Pardon.
12 on this month. I have little difficulty and I have not been here. So 30. I need pardon for this.
It will be there on 24th.
24th month.
As well.
item number 4,
Paying for a week. We see certain instructions.
24th. Yes, next.
item number 5,
This is a bullish. You are for whom?
No, I'm for the.
Who is advocate? Who is he? Where is he? Ask her. Yes. All right, let us hear it.
My lord, from the last project, my lord has already informed us, and my lord was of the opinion that since the appeal was not in the nature of maintenance, from the point of maintenance, my lord was will be producing a report for your lordship with regard to my application that as to how this application at page 70 was issued in my favor. That is, it was an application to appear for personal interview, whereas
Page.
70. Whereas it was the submission of the state that I was never there at the time of inquiry, field inquiry. But my lord, my submission was that until and unless I was present in the field inquiry, the page number 70 application cannot, notification cannot have been inquired.
Where is your 4th August representation?
My lord, that the presentation, my lord, will find at page number 73, my lord.
73.
Yes, my lord.
No. Your representation. You submitted a representation on 4th August.
Yes, my lord. This is the presentation, my lord. Date is 4th August 2020.
What is the wrong with the order? What is the wrong with the order?
My lord was in the last occasion, my lord was also of the same opinion that there is nothing wrong with the order, but I had stated that there was wrong submission. My lord was of the opinion that I should have preferred a
But your representation did not speak so, that you were not present at the time of inquiry.
So unless and until I was present in the inquiry, my lord, the page number 70 could not have been issued against me.
Page 7,
Page 70, my lord, this notification could not have been issued against me. Only upon satisfaction of the field inquiry, they will call you for personal interview. Only on this aspect, my lord, have called for a report.
no, there cannot be a fresh inquiry. What is, you are saying that I was not present. Court
No,
has
I-
wrongly recorded that medical ground I was not present. You were not present.
Present.
You were present.
I was present.
Very good.
It was my submission that I was present,
Hmm.
and only then after satisfaction from the inquiry, they expressed their willingness that I was a fair candidate.
Hmm.
Then only they allowed.
They called you for an interview.
They provided me this notification for interview. I appeared for them. They again expressed their,
Then they reject.
but they rejected without providing me any reason. And subsequently, they allotted the same subject vacancy to some
So
respondent.
what do you want from us today?
My lord, we just want that opportunity be given to us so that a reasoned order may be passed.
That is
after.
what has been directed. Come to paragraph 5.
Yes, ma'am.
Considering the submissions, respondent of a dispose of petitioner's representation on hearing the parties in accordance with law by passing the
Yes, my lord. But upon hearing my lord are also of the opinion that a second opportunity might be given to me. That was my lord's view, and I am only pressing on that matter. Just
Basing on what? That you would be given an opportunity of
to make another representation to the appropriate authority so that my
Sir, how can we say so? Your application has culminated in an order of rejection.
yes, ma'am.
After being agreed by that, you submitted a representation that there is no reasoning in that. You reconsidered the issue. That was your representation.
Yes, ma'am.
That is at page 73. You
Yes.
stated everything, a field inquiry conducted, and you were called for interview. Then it was suddenly rejected.
Yes.
Without any prior intimation or stating the reason.
Yes, ma'am.
As such, you filed the representation to request you for a reinvestigation in the approval.
Yes.
This is within the domain of the authorities, whether they will investigate or not. It is upon them.
Never conducted that inquiry.
Which inquiry?
The section based on my representation.
Your representation has been directed to be considered. Now, whether they will go for reinvestigation or not, it is their decision. What the court will say. Would you represent?
Actually, judgment হচ্ছে শঙ্কর কুমার 2003/9 SCC page 1.
Your statement was that court recorded you were medically unable to attend the exam. It's a wrong recording according to
Yes, ma'am.
how you are agreed, we still don't understand. Sir.
My lord, we have also prayed for the that the result order may be communicated for that was also.
Passing a recent order from the date of communication. They will pass a recent order for communication. Paragraph 4 of the order.
Yes, ma'am. My lord, the previous reason order, the previous rejection order may be communicated to us. That was never also communicated to us.
Which previous?
The initial upon which our application was rejected.
That is page 71. Hyder Ali, na? You are Hyder Ali.
Yes, ma'am.
No, rejected.
Just was rejected, but never it was never.
That is why reconsideration, sir.
Yes, ma'am.
No interference is for.
My lord, if a last opportunity be given to us
For what, sir? Opportunity for what? Tell us.
so that they could consider our once so that
That is the direction that they will consider.
no matter then
Withdraw the appeal and go to the authority. Today if we cannot further modify the order, na?
my lord, in that respect, will kindly keep the appeal pending, my lord.
No.
Just so that I could submit before your lordship also that they have communicated the order and subsequently I will withdraw the appeal.
No, that cannot be done, sir. Today if you suffer a negative order, that will affect you in the reconsideration.
Yes, ma'am.
When you are preferring an appeal, that means that you are not satisfied with the direction for reconsideration. Good,
Yes.
bad, indifferent. Now, suppose we negate your prayer. In that case, you go further down. No?
Yes.
We ought not to have explained this to you.
No, my lord, I don't.
যে কমপ্লিট করে আর ওই যে বিষয় ইয়েছিল সেটা আনফিট ওটা নট অ্যাকচুয়ালি কারেক্ট বলে ওই ডোন্ট ওয়ান্ট ইট
Any decision has already been taken.
Lordship, on instructions, though Mr. Chatterjee is assisting me and he has not come to the court today, here 5th of February, most probably they will be called as my instructions are.
So it has not been.
No, they will, if Lordship records it and we are ready to give it. Or his representation, he can make, they consider. Yes, this is what I have understood from. Because since Mr.
5th
Chatterjee
February is day after
Day
tomorrow, no?
But he has not received any notice.
that I will ensure that he receives it. There are so many modes of sending it as soon as possible. Kindly.
Now, have you been sent the written instruction?
No, Your Worship. I have been just informed verbally.
How can we proceed on that? No? So you do one thing, we are keeping it next Tuesday. In the meantime, if you are called for a hearing, go and attend.
Yes, ma'am.
We will record that and dispose of it. If any fresh order is passed, avenue will be
Yes,
opened.
yes.
Next Tuesday.
No order is being passed.
No, we don't know now that whether 5th is. Simply adjourn. Yes. You go and attend the hearing if you are. Yes.
Item number 6. Last week, there was called on Melody. The matter of 3. I am ready. The verbal order was passed by the judge.
But I appear on behalf of the applicant, can he also be an application for addition of question?
Leave to appeal Melody. On behalf of the
Yes. Then the writ petition has been dismissed.
You are opposing the leave. So file your opposition.
An immediate signing may be given because the interview process is going on. We are intended to participate in the ongoing interview process.
Within a week, Mr. Sharma.
But the appellant is not come up to challenge the order.
No.
Rather, you are not party to this
Appellant
proceeding.
has also filed an appeal. Mr. Dasgupta, this order was suffered by Mr. Dasgupta. He has also filed an appeal.
Dasgupta has not suffered.
Which appeal? That has been filed.
Yes, my lord. This order has been carried out in appeal before your lordship by Mr. Dasgupta's time.
So then have we passed any order in that?
No, I had a talk with Mr. Dasgupta. He said that yesterday he has mentioned the matter.
We have not been served. Service করেছে? Service করেছে?
So very good. When we have kept that appeal.
But that I do not know presently. My lord.
That was not yet listed.
No, he has mentioned for listing.
But any event we have to file, we have to file an opposition.
The issue remains the same. My lord. If your lordship is
Mr. Sharma, then if we make.
No, my lord, these two are different. Two are different in the sense, I tell you, lordships, he have accepted the situation. He has not approached the learned single judge against purported inaction, action, overaction of us.
No. We are not saying that. We are saying that if that appeal is made returnable to us, along with that we will consider.
But we have to file an exception to this.
Exception to what?
Well, to this, have a leave
Yes, we will hear you and dismiss it then. If it is so.
without affidavit.
Without it. Or because if you want to file an affidavit, then you remind us if that appeal comes to us. We will keep it then on the returnable data.
if that appeal succeeds, my lord, we may not.
It may not proceed with this appeal.
Exception.
Malad, if that appeal is succeeds, he will not get a demand.
Very good, very good. What is your leave to appeal application now?
Can one.
You know?
And the can one of 2025.
But with the loss, I can remember at UPL fees matter, that general.
Yes, I told that you should.
But we have suggest the date 18th or 19th February. Anything.
देखो तुम्हारे आर्टिकल में उनसे
Then I communicate. We just talk.
3 p.m.
All. With all probability will go on at Jordan because Learned Advocate General.
Pardon.
Since now Learned Advocate General has entered, initially he was there. But after that,
Yes, we told him that we have heard out.
no, I am not on that. It's good. But Advocate General, every possibility adjournment will be placed for it. Because it's new
this সময় দেখি সময় যেটা হ্যাঁ for applicants in Canada.
Children of it now are actually.
I don't know what's happening.
Second, SLS. The petitioner filled up the form. Is the PH
No, I am appearing for the School Service Commission.
Yes.
is the PH category, very important. Now, what are the experience certificate or experience? It was not added. So at the time of filling up the form. And there was no provision at that time for giving experience. Whatever it may be, the School Service Commissions will consider the matter and one time they will, in terms of the course order, they open the window in which all the candidates who got experience may submit their
Well,
Mainly, I submitted my applications, but it was not taken into consideration on the technical ground. The invitation initially was directed to consider the matter. Thereafter, consideration was made, and what consideration was made? They said that he attempted, but not to fill up the entire proceeding. He attempted only 5 minutes window was open. And I being the teachers not experienced in the technical 5 minutes window was open. I have given them experience certificate was accepted. It was not said that it was rejected. Then it was not considered. The
No, you uploaded it.
Yes,
Uploaded the
I
certificate.
uploaded the certificate, but there is a technical term which I have come before you. And thereafter, result was published, and result was published. My experience mark was not added. So, I am an unfortunate person. Seeing a job given the Supreme Court decisions, I was initially the teachers, but after the order 2016 SLST, I lose my job. Now, my lord, your lordships, can you see that these, whenever my lord, I deposited. Page.
Where is that order of the commission?
Yes. Well, the order was the commission,
26
page 61.
December.
Page 61. Page 61. Before that, your lordship kindly page 49 kindly go.
Attempted to provide. Attempt is pertinent from the verification just page 27.
Page 49, if your lordship kindly test trouble.
No, where is that page 27 of your dictation, that is annex 12.
Page 27.
The order imputes says that page 61, they said the attempt is pertinent from the verification token annexed at page 27. Where is that?
Page. Oh, there must be application, it is page 49.
49.
Page 49.
It was not uploaded. Mr. Bandyopadhyay, it was not uploaded.
It was not uploaded by him. What has happened to Miller when the original application was filed, he did not mention about any experience. Right. Second, Miller, we gave an scope to edit. When that notification was given, he only attempted. And it was 5 minutes, is given. That time one has to fill it up. He has to give in the certificates. He didn't give the certificates.
Why did
From 5th to 12th.
Your lordship kindly.
From 5th to 12th, August, from 5th to 12th August, 7 days their scope was there to edit. The first edit was not done. The second day he could have tried. He tried. Thereafter, he did not give the certificates.
No, when he tried means she wanted to upload. Then
it was open. Upload. Then 5 minutes were given to him. 5 minutes were given to him.
He did not upload.
No, he did not upload.
49, your lordship kindly see that this token was given after uploading.
The problem is this, Milord. The problem is this. He, in his own original application, he did not mention about the experience.
Now, very good. The editing option which was ultimately granted by you.
Actually, it was granted. What I am submitting.
In the original application, it was granted.
He has not given it. Now, second time he was given chance. He did not avail it properly. Let's assume that he has given in the experience so years. At the time of verification, they could have given.
It is
How such an irresponsible man can be a teacher?
If first there was no provision for uploading the
And ultimately, now the result has already been published. The result has already. Now we will start the counseling any day.
If the genuinity of the certificate, there is no such doubt. And I was
Mr. Badi, it is not a single candidate examination. No.
Mind you, when it is the first submission should be, there was no provision for.
In fact, the learned single judge has made an observation that he has come at a belated stage.
The experience
And he's saying that the learned single judge order.
In terms of the course order, second option was not a second. That was the 5 minutes window.
Where is that order? First order? First order granting you leave to.
No, I have not filed the petition. By course order, they open the window for 5 minutes.
Oh, not
Not
in.
mine. in general.
So your original application is page 47.
No, this is not correct that because of the court's order we have given the chance to edit. This is not correct. Today, my learned friend has not read the brief properly. Egramur,
Page
poor Baba.
47, page 47 is your original application.
Yes.
So there you mentioned physically handicapped, hearing impaired. Category physically handicapped, hearing.
Physically handicapped, that is not the question. The question is experience. Experience, I am serving the another institute as a physically handicapped person. If the experience is taken into consideration, then my 10 marks will be allocated. I was serving another institute. Now I am losing the job in view of the Supreme Court judgment. That's why that experience was not taken into consideration, and there was no, your lordship can see the in the form whether there is any column for experience. Date of birth, subject applied for, medium of the vacancy, category, caste certificate, gender, mobile number, email address, religion, Bengali language study, application fees, address, corresponding registration date, registration status, application date, application status, training type, venue district, venue area, academic qualifications.
You did not provide the teaching experience during submission of online application. You are meaning that there was no column for experience.
Teaching experience.
Huh? There was no column.
No.
He is incorrect. If the application in the form, if we fill up the experience, then this will come after this experience. The losses have examined so many. He did not fill up the experience. He is not telling the correct fact.
That is what we are wanting to know. Where in the form there is a column for giving experience.
But once it is filled, it will show. If somebody does not fill it, it will not show in the printed form. It's always there. It is always there, experience. If I say fill experience, then it will show in the printed form. If I don't fill,
Oh, then it will come down.
Yes, madam. It's not it cannot be that the experience column is not being shown or has been shown or was not available.
Can you do anything, Mr. Gondor?
No, my lord, this is everything has been done. For because of one person, nothing, entire thing cannot be disturbed. Topsy-turvy, it will be topsy-turvy.
It is not.
And he has come and implemented. Kindly see, appreciate this. In the month of August, it had happened. He did not come. And your lordship has seen that before that I have, since your lordships have made an observation, I have considered everything.
Initially, your lordship kindly have a look to this two order of the court. Page 54.
Give us chance to file an affidavit.
Result is also declared.
Page 54, your lordship kindly have a look. The first
Give
order.
us chance to file an affidavit. Let me file the affidavit because
Result has been declared, Mr. Badi.
How, the court is not powerless. If the result has been declared, now under the appointment, your lordship keep one post reserve. Decide the issue.
A delinquent person will get benefit. Lakhs and lakhs of candidates are applications. It is very easy to say, Mr. Badi.
Reservation merit handicap category is not a that.
Why didn't you apply, Mr. Badi? There were 7 days time.
No.
If he had any problem, he should have contacted you. That I'm not
one day the window was open and I did it.
No. It was open for 7 days. Not 1 day.
I
tried to from
We give one copy to him.
we have the notice, kindly see notice. 1st August 2025.
From 5th August till 11th August.
5th August to 18th.
5 days was open.
Did it.
5th, 6th, 7th, 8th, 9th, 10th, 11th.
How can I know that this is not the completely, it was not uploaded?
So how will it be uploaded? When you fill it up online, when you press for experience, it will come down. Then you have to incorporate, Mr. Badi.
No.
Maybe he was not aware of this situation.
Mr. Bari, page 49
Yes.
is your token OTP. Is
Yes.
such and such token is valid for 5 minutes.
Right.
That means that OTP is valid for 5 minutes.
How can I know this is not
Then
being
again
accepted?
you come, another OTP will be generated.
My submission,
And validity will remain for 5 minutes.
I submitting that I did it.
Admit emergency.
You did it on 5th August. Only on 5th August, one attempt. There are no other attempts.
5th August to 11th August, it is not rejected.
Mr. Badi, if it is not uploaded, you will not say try second time. If it is not
How
uploaded.
can I know it is not uploaded?
No, no,
It says that it is.
that is a token OTP, Mr. Badi.
Right.
When you are filling up,
Yes.
when we say that I have experience, then the column will come down that what experience you have. Good, bad, indifferent, your client had a problem in filling it up. Now there it was open for 7 days. He did not come within that time. Now after results declared, how can we exercise discretion in
Because
it?
before publication of the
Or
result,
let them file evidence.
if all the post filled up, then your lordship kindly.
Then at that time we will consider. The present evidence is therefore challenging and undertaken such and such. Such and such. Hearing Mr. Badi that the dead will be appearing for the appellant and Mr. Bondupadhyay, the next senior advocate appearing for the commission. We are of the opinion that the matter needs to be decided upon exchange of evidence. Accordingly, the respondents are directed to file their affidavit in opposition within 2 weeks. Reply
No, not 2 weeks, not 4 weeks. Give me 4 weeks. We are writing 70 affidavits. My juniors are writing 70 affidavits. Give us 4 weeks.
Write one more evidence. 2 weeks, 1 week. List the matter for further consideration on on 5th of March. Yes, it is something.
Deeply obliged to us. Deeply obliged. So many affidavits.
The lordship is not inclined to pass it.
Any action taken will abide by that goes without prejudice.
Let it be. For our satisfaction, let it be.
In my entire career,
Your lordship, one line, your lordship that, your lordship is not granting any extreme order, your lordship on that extreme order can be. Your lordship can
Needless to observe, any action taken in the meantime shall abide by the result of.
Yes. Is not the attended candidate, is the objection.
Stay up.
No, on 6th you will not attempt, on 7th you will not attempt. You ascertain.
After inflation, it has been accepted.
No, not.
Technical expert.
I don't know nothing successful or completed, anything like will not come.
That you cannot say I'm not the technically.
When we register something successful or completed, process is completed, anything, such sort of remark will come at the end.
We have to see the computer is.
Can number can 1.
Yes.
This is an application for stay filed in connection with the appeal being approved, preferred challenging and order dated such and such, fasting such and such. Upon hearing, the application needs to be heard upon exchange of evidence.
Yes. In my entire career, it's such a short duration, so many affidavits are, my juniors are doing work. What has happened? He has done already 40 affidavits, 45, another 17. Yesterday he went to bed. Then at 10:30, something came that there's a division bench order, affidavit has to be filed. After from 2 o'clock, he started to write the affidavit. I must give thanks to my junior.
No, right.
They are trying.
Yes.
Deeply obliged to your lordship, deeply obliged.
Yes. Item number 8.
etiology appear to the applicant. Should carry over into last one, 14 January.
Not the first one.
The first order, 3 times opportunity was given to the state to file a report. Till date, no report has been filed. The lordship categorically said that in this occasion, if the report is not filed, lordship will ensure physical
For direction of their
finance.
only in the direction was. The direction was upon university to send document.
Today, people are testing our.
We have said, my lord, but the motion was there, my lord, just now. He told the petitioner's advocate that evidently it's not ready, my lord. Test, do what test time is required. I have said.
You know, but it's the state now. State is continuously dealing the matter.
So you have sent under a covering letter or anything? Show that covering letter that you have sent.
The Lord will tell you.
Mr. Officer.
Oh.
Yes. That is my signature of Mr. Officer's law. Mr. Shen is here.
What is ready, but
Yes, Mr.
Eventually, we got this so far. Whatever our requirement was, we have finance, but only according to them, through mail, they provided it on 23rd or 24th. But my instruction is that they have not received through mail. So even third copy. And the finance, they also collected from me on last Friday. Kindly give me 10 days time. I think everything will be solved after that. Whatever the report is.
Go through our last order.
Yes, I have gone through. It was forwarded to them. We received it according to them from the collect that they provided it through mail, but we have not received through mail.
Next Tuesday, you file it and you share.
Tuesday,
Mr. Sen.
Make it fast. What better than other thing? I have marked that one on my ground.
The earlier direction that
12th February. 12th.
12.
Well, it is
No,
embarrassing for us.
I think, my lord, that now, my lord, I think there will be no problem on the next.
No, I did not understand.
12.
They have not received the documents.
They have received it. They are filing it within 3 or 4 days. And he has prayed for 7 days. We are keeping. It is very embarrassing for us. This way it continues. Then we make it clear. The report is not there. We are asking the principal secretary to be here.
I think
it is only because you are appearing, we respect your stand, that is why we are giving it. But your client should not think that it is a weakness on our part that we
there is no such
such indication moves when the court starts respecting the advocates and
when I am appearing, there is no room for that perception because of the fact. We received it. We have also forwarded it.
Very good, Mr. Sen. Till down 12th, you will be here and shared the report. Otherwise, again they will submission and
he will not get any chance. He will not get any chance.
Order be passed so that it is on record.
We have passed 3 orders. We have on 12th we are directing personal appearance if the situation so demands. Yes, next.
Very good. May I take Lordship kindly pass an order that will be the last chance for filing report at least so that to bail me out also. I can also.
That we have given in our.
I know that. It is in the order.
In the order itself, it is there.
Order is.
Yes, next.
Item number 9.
That I think 9 minutes. it is that matter, the petitioner has appointed upper primary level, pursuant to Rajiv Kumbu's order passed by your lordship. Petitioner has been appointed as upper primary level election process, your lordship's Rajiv Kumbu. But at that point of time, petitioner was working as a primary school teacher. But petitioner has newly been recommended by the West Bengal Central School Service Commission. But due to some personal difficulties, petitioner now 90 days is provided of 73 of the
No. You were recommended as an upper primary teacher.
yes.
That recommendation you did not go and join within the time. So you are wanting now extension of.
Validity of recommendation and
But we have held against you in a similar matter.
what happened, my lord? I am at this position. My lord, position is here about 5,300 vacancies are left, and my lord, candidates left, my lord, 1240. Or my lord, who are 20 candidates who have not been recommended council. Even there are 1242 candidates. Still now they have been not been counseled. They are facing, my lord, contempt application has been filed.
But why didn't you go and join?
My lord, that
Your latches are not
Yes,
latches.
yes,
Your latches are not latches.
yes, my lord.
Huh? And now you are saying that this you have done, that you have done, give me this benefit. See his conduct.
Yes.
A person was without job from 2016. By virtue of court, he got it. Recommendation issue. Even now, they are now not recommending the remaining persons. And we are going on in a tug of war with them. These people will never understand it.
My lord, what happened, my lord? Subject to correction. my
What
lord.
can be your explanation? The why didn't you go as per the recommendation?
My lord,
You will sit at home and think whether this service will be better or which one I am doing that will be better. Is there any scope to think?
That is true. But my lord, subject to correction, my lord, within 150 days, my lord, 70 provides 173. 173 is clear. My lord, recommendation.
Have you seen our judgment which we have delivered? You have that order. That Somnath, that Shimui appeared. That to Bharot Shimui ta koto. Bharot Shimui.
My lord, my lord, I am in my hand. There is
Yes,
an order.
yes.
My lord, this is the fact of this case. My lord,
So,
petitioner-
tell us.
My lord, petitioner has participated in the upper primary selection process. My lord, subsequently, my lord, they are waiting for the declaration of the panel. Ultimately, my lord has passed an order in Rajiv Kumbu's case. Your lordship directed to recommend who are shortlisted are 14,052 candidates.
That is page 36.
So, my lord, 36. My lord, I have not annexed Rajiv Kumbu's case. my lord.
Aha, your recommendation.
Yes. Recommendation is, my lord, page 36.
21st November 24.
It's 2024.
This
21st
was in terms of
Rajiv Kumbu's.
So this thereafter you were called for counseling. Thereafter you got this vacancy recommendation.
There, first company.
Yes, you were placed at
Kindly see, my lord. Then, my lord, next page, 37, my lord, school authority. So, Rameshwarpur Junior High School duly called me for the document verification. Thereafter, my lord, what happened, my lord, in page 38, my lord, within validity, my lord, after 90 days, but within 150 days, my lord, I made a representation before the West Bengal Central School Service Commission. That, my lord, representation.
Yeah, just.
Yes.
Recommendation was 21st November.
Yes, 21st November.
29 November, school asked me to appear. Then what happened?
Then, my lord,
you did not appear.
I did not appear, but 7th April 2025, I made a representation before the Central West Bengal Central School Service
That is
Commission.
after 4 months.
After 4 months, within, my lord, at the 137 days from the date of issuing of the recommendation, 137 days. My lord, I made a representation.
That is not within 90
days, but within 150 days. My lord, commission has the power to further extending, my lord, 60 days, but not beyond that. So 90 days and 60 days. It is almost, my lord, 60 days, they can. Within that time limit, my lord, I made a representation before the commission that I have some difficulties that I could not join. Kindly extend the validity, extend the period of validity of the recommendation that I could join. This is the position. That commission has not considered, not issue that representation is still pending before the commission. Then, my lord, I filed a reapplication before the honorable single bench. Honorable single bench said no, 90 days is the cutoff date. That recommendation is valid as per the proviso of 73, my lord. Recommendation strictly valid for 90 days. After my lord 60 days, it is their discretion. So it cannot be, authorities not in position to consider your application representation that honorable single bench turned. My lord, against that, my lord, my lord,
Yes,
my lord,
this was the order.
my lord, order immediately is the order. Kindly see the mat. My lord, this is the, my lord, ultimate copy of this order that I taken leave by 5 minutes.
You have not annexed it. You have stay.
My lord, server copy, server, yeah, no, it's not, my lord, this is in memo, my lord, kindly turn, kindly, my lord,
It
memo, memo, my memo, my lord.
Harvard copy also you did not annex.
My lord, at that time, my lord, hurriedly, I have seen, my lord, in memo.
তোমার কাছে আছে copy?
Memo,
Where is the copies?
my lord,
Order it.
Order.
memo, my lord, server
Achha,
copy, by
server copy?
using server copy, my lord, I filed this.
Hmm.
In memo of every, my lord, it has, my lord, order dated 4th of September 2025. My lord, relevant part is paragraph 3. May I please?
Yes. Your representation was beyond 90 days. Then how can we help you?
My lord, kindly see the ones, the proviso of 17.3.
Yes.
My lord, that
Proviso will be operative subject to an application within 90 days. No?
my lord, but my lord, it is in their opposition, it has been in their opposition, they have admitted the fact that beyond 90 days who make application. One I have said example, Rinki Poddar. Earlier occasion, my lord, I delayed that order for your lordship. That Rinki Poddar application who made application beyond 90 days, but the authority had accepted. They have admitted the fact in the
No, no, I've also distinguished the fact. I have not simply admitted.
আমাকে
It was which I have done.
my lord, kindly see their opposition once.
The issue is whether your application for extension in terms of the proviso will be considered only if the application is made within 90 days or not. This is the
This is
very good. Show us the opposition.
not opposition in middle.
You have said that this has been done in case of one ring.
Ring.
In that case also application was beyond 90
Beyond
days. Such a show the paragraph.
my lord, they have in paragraph. My lord, paragraph page 4, paragraph 8. My lord, Rinki Poddar's application, my lord, they have annexed, my lord, also. Recommendation is below. 23rd of December 2024. 23rd December 2024. Now Rinki Poddar made application for 23rd December 2024, page 9, annexure there, affidavit annexure 9. December 2024, and below page 10, representation of Rinki Poddar, 7th of April 2025, which is beyond 9. That document I have furnished also given. Page 10, 7th April 2025. Some medical issue is there, but issue is there. Rinki Poddar medical issue is there, but application is beyond 9 days. Not only this, my lord, I could not arrange that document, but it is true. Another several candidates have made application.
Okay, I have annexed the letter.
Which letter? That is Rinki Poddar's letter.
Yes, where she has clearly stated that.
No, you are harping so much on no, that we will give reason
Yes,
only when we extend. So have you given reason in that? You have filed a report in the form of an evidence. Show it us.
kindly let me check. I think it is annexed. Yes. But kindly see page 11.
11.
Yes, of the opposition.
What is the reason you have said?
The reason is in the resolution that is not annexed. But on the basis of the letter which she had
No,
submitted.
you are harping so much. No, we will explain. Proviso, we will explain.
Yes,
What is that explanation?
to be given in writing. That this is kindly see because I am directed to inform you that in accordance with resolution taken in the 530th meeting of the Central Commission held on 20/2/2025, the Honorable Chairman, with the order dated so and so, has been pleased to extend the validity.
Exactly. We want to see the reason which is spoken of in the proviso. Reason.
Yes, that will be in the resolution.
Bring the resolution.
Very well.
The resolution is prior to that. Resolution 20th February, we applied it the 4th of April. It's the
No, resolution is 18th of April.
20th February 2025.
Where you are reading?
Resolution taken in the 538 meeting of the Central Commission held on 20th February 2025. That resolution taken February. This is a Rinki applied April. So prior to that resolution has taken. How funny.
No, the chairman by order of 18th
It is
April.
funny. This is an example.
He has a right to access to the court.
I
You
also
say
have a right
anything.
to oppose kindly. I also have a right to oppose kindly.
What we are doing, we are not allowing.
But by that right, he is harping only on Rinki Poddar. She came
Naturally.
within 3 days because she was in hospital losing 2 babies. If I do not violate the rule on that occasion, then I have nothing to say. If I do not relax the rules on such an occasion,
Exactly. So you have a power to relax for ABCD reason. Question is whether at all you have.
no reason. In this,
That is
my knowledge
Dr. Pathro, don't submit something which you also know is not proper. We are on the issue that whether you can exercise the power of relaxation in cases where an application is submitted beyond 90 days. We are not questioning your reason. You are right that in that sort of a case where 2 twin babies had expired and it was made 3 days, we will consider the special circumstance. That can be differentiated in that manner, but you cannot start your argument saying that no, we are not bothered with such representation.
No,
When you have that sort of an attitude, then the court will find that what your chairman is doing.
Yes, kindly.
So
But-
you
But
bring,
the representation of the
we have accepted.
yeah,
Which
kindly compare it to Rinki Poddar's representation. I'm not going into the time frames. Rinki Poddar came within 3 days. Petitioner came after 137 days. I'm not going into that comparison, but at least compare the contents of the
are you telling
representation.
him to extend the validity? Are we telling him? We will, if we pass an order, if we pass an order, we will guard our order also,
Not
which will
that-
not take away your right to appropriately consider. In that order, you will give the reason. That there it is a special case.
Yes, that is my submission. That Rinki Poddar is a one very rare occasion this kind of situation arises.
এই 18 তারিখে
Rinki Poddar's recommendation letter was 23rd December 2024, requiring him to join within 20 January 20
Within 90 days.
January, February, March. That is within 22nd March 2024.
Yes, representation 7th April. Is saying that
Representation
7th April 2025. That is page 10. While other page saying within 2-3 days. differentiating with my case. Is an immediate
In that
impact.
circumstances, not 3 days.
No, kindly speak. I have against everything. Kindly
Yeah,
speak.
she was required to join within 22nd March 2024.
Yes.
25.
25. But he prayed for extension of validity period.
After 90.
Seventh after 90 days, that is.
Hello, kindly. Beyond 100 days.
Actually, Mr. Patro, kindly consider the language used by the legislature. The recommendation shall remain valid for 90 days.
Yes,
That means on 91 days, it would be invalid.
yes. And from that day.
And the commissioner has been given power to extend the validity.
Yes. Yes,
That means to give a further life for 30 days.
60 days,
More.
up to 60 days, up to 60 days.
Okay.
150.
So,
Total 150, total 90 plus 61.
so extend the validity.
Yes,
It is already invalid. Then the power cease to extend.
yes, that is absolutely correct. I am not even once am I disputing that provision of law. If I do that, then all my arguments will be destroyed.
That is exactly what it is.
But this is one standout case.
আবার বলে ওটা have we said so?
She was in a
Consider and throw away his representation.
Yes.
8 reasons.
that I am subject.
How do you dare to compare yourself?
It does not provide the time to give a reply to each and every applicant. Only if I
Then you are
allow,
taking your argument to a different pedestal whatsoever. You are asking the court to determine whether there is any statutory obligation on your part to answer a representation. That is a higher pedestal argument which you may argue that
in
appropriate.
a non-state situation, in a non-representation, it should be replied always.
Yes, we only want that.
Very basic that if I reject, then I am to reject with reasons. This we have always submitted an argument. But this particular rule, it has given an opposite provision. That if you allow, give reasons. So only when we allow an
And you
extension,
reject giving reasons, finished. Your case and Pinky's case is not similar. Reasons and finish it up. ও মানে কিছুই করবো না।
জায়গাটা বেরোলো।
এই সেটাই। কি করে দেবে?
Appointment letter.
Oh, that was uploading of vacancies. The 90 days এর পরে one.
90 days এর পরে আপলোডেড মানে
হুম।
ফার্দার ক্যান্ডিডেট করতে রিমেনিং ক্যান্ডিডেট হচ্ছে ভ্যাকেন্সিতে অ্যাভেলেবেল হবে।
yes, that was actually different.
হ্যাঁ
That 90 days.
No, no.
period of the
In that circumstances, there was a 60 days, matter of 60 days more came, we can recollect, where from 60 days.
Job leaders case, my lord, I can show. My
This
lord,
is not a job.
my lord, job, your lordship pass, upper primary selection is respect of.
আবার যাও কোথা থেকে
No, no,
কোথায়
no, my lord, since the issue is the same, extension of validity of recommendation, but they are the job leadership, your lordship extended that after who are remaining part at 1242, after 1242,
that
they
is
can.
Rajiv Brahma.
Oh,
No, Rajiv Brahma, ratio of Rajiv Brahma, but some candidate who are working the first SLST, losing their job, they made a prayer for extension of a recommendation in upper prime. Honorable single bench allowed, they prepared an appeal. Honorable, my learned will prepare an appeal. In that case, your lordship observed, first matter towards the remaining part, 1242 is the remaining part who have not been counselled yet. After 1242, they have been required, they have been counselled. Your lordship observed, and honorable single bench also, if your lordship observed.
no, we are not talking about that judgment. We got an occasion to deal with such period of limitation recommendation in another judgment.
Yes.
Question was that whether immediately after 90 days or 60 days thereafter, this vacancy will be made available to the next candidate or not.
Yes, yes.
In the next counseling or
But
process.
usually it is not effect of the upper primary past lessons.
Where is the embedded in scheme right? Extension 90 days.
We are
Beyond 90 days, but not beyond next 60 days.
150. Within 150 days. Beyond 90 days, but within
Within
150
150.
And also.
But in Rinky's case, the vacancy ceased to exist. The vacancy ceased to exist in case of Rinky. She was transferred to a different recommendation.
না, যখন after validity.
Extended. In his case, when the Rinky made application, they have extended the time. Rinky went to join that particular school. At that time, Rinky found that school is not vacant, there already another incumbent has. Then Rinky made a further representation for re-recommending in another school. At that time, they have not considered honorable court, honorable significance directed, yes, if he should be recommended, since it has been recommended, he should be recommended in another school. That is the, yes.
Then that 60 days extension was on the basis of Rinky's request, representation.
Yes,
That 30 days.
yes, no, 60. Extension 60 days, but 30 days, what?
30 days.
Yes,
In case of Rinky, secretary first extended it for 30 days.
30 days.
But on that basis, when she went to join, she found that the vacancy does not exist. In such case, court directed that
Another 60 days.
And that is the usual practice. If I recommend a candidate to a school and it is found that the vacancy was wrongly given to that candidate is already filled up, we normally re-recommend. That provision is. It was not a special, that part was not special.
if you can show us that this 30 days extension which was made was backed by special reasons of that case, then your argument we will consider. If you argue that because once we pass an order to this effect, that means whatever representation filed beyond 90 days, the person will be having a right upon you to have it. Now, if you can show us that in case of Rinky, that initial extension of 30 days was backed by some reason to that effect, then the question of differentiation is there. In that case, we don't have to interpret the rules.
What is your gown?
But ground is without,
You show his certificate, let's see. Everyone will come with the certificate. Whether you are trying to,
Find this page.
you are seeking parity with Rinky. To speak the truth, in one word, you are seeking parity with Rinky. So Rinky, we have been told that Rinky suffered an unexpected incident. Her two twin baby were aborted and so on. Now, how you can equate with
not
Kindly
to correct.
separate by non-reference representation. Nothing is there.
Subject to correction, not only, I have already.
no, you are seeking parity with
Yes,
Rinky.
I not only.
The Rinky has been
We
given.
are accepting
Yes,
your
yes.
condition. Otherwise, we cannot consider.
Yes, so let them.
We are accepting that there may have been an obligation on their part to consider your representation, though submitted beyond 90 days. Very good. Now, what my brother is asking is, then that means that you are claiming parity with Rinky. Now, instead of relegating it to the commission for consideration, if we find parity, we will direct them to recommend you.
But isn't they have shown.
Come to page 38.
Yes,
I have. কিন্তু বিভিন্ন কারণে ওকে বর্তমানে আমি প্রাইমারি স্কুলে অ্যাসিস্ট্যান্ট টিচার বর্তমানে আইনি জটিলতার কারণে আবার যোগদান করিতে ইচ্ছুক। It is 7th April 2025. বিভিন্ন কারণে
That has not been.
miscellaneous reasons.
And Rinky's order, and another way, better matter
Miscellaneous.
proper instruction, but Rinky's order, extension order, there is no reason as to that might not be planet is
So it satisfy us the reasons, no?
Yes, that is.
It's a representation of it. Signed,
Just an order.
Far from is again.
it is part of our opposition, can we see?
Oh.
Page 10, Just read it once, kindly. In third paragraph. And the dates are during the period when the recommendation expired.
Temporality. You even did not disclose the reason. Miscellaneous reason, various reason. বিবিধ কারণে। So don't claim parity with Rinki. Rinki is a special circumstance. One mother has lost two baby.
But they order passed. There is no such restriction. Why this extension has made?
That is the reason, sir. That is the reason, sir.
But my lord, subject to correction, my lord, it's the article 12 of it. My lord, my attendance client is article 12 of it. My lord, I am not on that position.
Can you term it as a discrimination, Mr. Ghosh Chaudhary?
I made an order, it is also, my lord.
Accepted. They were under an obligation to consider. Accepted. If that explanation we can give, but we have to send it back to them, count commission for what? That you consider whether in Rinki as you have given, whether you will give it to him. That will be rejected, special ground.
It's a special ground. But my lord, order they have.
Tried your best, Mr. Ghosh Chaudhary. We also tried our best.
But at least my representation is pending. But it is the right of the candidate.
We are taking up your representation. We will not send it to the commission. We are taking it up. Approved service. Present appeal has
But item number 10, last provision is also extended the exchange of equity for further period of 3 weeks. Yesterday, I have received opposition from my learned minister. So your lordship order is there. It has wrongly, it has possibly wrongly in that order.
The case is identical to the.
No, I have.
This is beyond 150 days. Beyond 150.
আজকেই একটা হেরেছে পরের দিন হয়
I have to put the position with it. Yes. And my lord's order, judicial order is there. It will come after 3 weeks with a class.
Dr. Pathul and the advocate appearing for you are appearing with the nineteen weeks school থেকে 19 same order in the next one.
No, my lord, here my lord is issues the same, but here is the has already given reason why that recommendation should extend. And kindly see only that much I am want to put. I will not take much time. Medical reason is illness, my lord. Page 30 is the prayer for extension of validity of the recommendation. Medical reason is there. My mother's illness and at present my lord, wife is on. My mother comprehensive my lord, medical document I have annexed in the honorable single bench also. But here reason is specific reason medical reason. Page 30. Medical document I have annexed. So it's some slightly differently.
You applied beyond 90 days.
Beyond 90 days, but within 150 days. But it is in medical days. Don't let the authority be considered. It has not been considered.
Mother's illness and candidate admitted in hospital undergoing surgical abortion, I don't think they can be.
My lord, similar circumstances.
Mother's illness cannot be.
My lord, similar circumstances, honorable single bench hospital order, I can show you lordship.
Tragic situation.
But similar, my lord, issue has been laid with the honorable single bench directed the commission to consider it. However, this case has not considered the specific illness, background of illness is a specific.
What is the date of your representation? 13th May.
My place.
Date of representation is
coming to
but date of representation is 13 May 2025.
yes.
And recommendation is made on 19th of February,
December
2021. No? It is just within, it is at
So
the time-
next page 32 is the medical
yes,
patient name is Farhana Azmi.
yes. Serious due to serious illness of my mother, I could not.
Yes, Farhana Azmi is your mother.
No, Farana is my wife. Mother is there.
You are also primary teacher.
I am also practicing.
Your medical certificate, page 24 is page 24 is of January 25. Page
It is
page
going
32.
yes. January 2025. And after issuing my
Ja,
recommendation,
let us see. 1st of June 25. Then 21st, 24 December 24.
Contemporaneous medical. But 24th of December 22 page 7. 24th of December 2020.
What she was suffering from?
What she was suffering from? Bed rest or this it is too. But what suffering from? Very clear diagnosis.
কোথায় ফাট?
It-
দেশ না 2 সপ্তাহ বাদে আবার দেখা।
Oh, report after 2.
This is 1st June.
That he was in such a condition that he could not join.
But was working in the other school. There the candidate must have been attended.
That school is nearer to my place of residence.
What is page 14th of June you made another representation?
14th of June, we got another representation. Since it has not been considered by the, it is from the rest of the school where I have been recommended. School is seeking me. Since there is a shortage of staff, but at school also seeking. And my lord, next page 41 is the from the my lord regional school service commission. It has been forwarded from the regional school service commission that a person is facing some trouble. Let the recommendation be extended that he can join the school. It is from the page 41. It is from the regional school service commission to the my lord central school service commission.
And where is the नहीं बनी थी इतनी कमीशन नहीं बटे
Yes, definitely.
yes what you are showing
My opinion.
Consider doing it.
Okay, page 9, my opinion. Page 9 in my opinion.
page 9
Because himself that says that I cannot join the post
Page 9 of
of our opposition state final state.
Riktopal.
this is given on 21st of January 25 oh. Good. Mr. Ghosh Chaudhary, what do you have to say about this? Page, you did not, you yourself said I don't want to join.
Unavoidable circumstances.
Hey,
It has not been categorized that by into my list of the matter where my lord
This was on 21st of January 25. That is during subsistence of your ailments of your mother and wife. You said I cannot.
it has not been and during the validity elaboration is there. But my lord, subsequently, my lord, where the who is the ultimate authority, but school is not the ultimate authority to extend my recommendation. My lord, but chairman is the ultimate, where I categorically stated the reason. Reason has been accepted. Let the my lord some medical issue that reason has been shown.
Here also Justice Bhattacharya passed the same order.
Same one. And my lord, similar situation, medical issue is concerned. Same Justice Bhattacharya passed an order that let it be considered by the.
We are not satisfied now. Dismissed. The order is dismissed. ওটাই এখানে Yes, next.
Item number
You can
12.
withdraw it.
Well, it's similar issue, but not received the, but issue is the same.
কবে রাখলাম সেটা?
I have not yet received the opposition from the state.
Great.
I have received from. Yes,
given we have
but
also
earlier on,
reply.
directed to file this, extend the time limit of filing opposition from the state, but state has not yet given. Also,
Next week you will fight. এই 3 তারিখ দিয়ে ওই আগেরটা কবে রাখলেন? 19 তো 19 তারিখ। Yes, next.
The issue is similar, but I have a different approach in this case with your lordship, and I'm not going to be carrying. Your lordship, I can take it today or any other date. Subject to lordship for me.
Today. 10
I have a different time to other judgment to share with your lordships. In a similar occasion, what has allowed this? And my lord, they have to, may I?
You have used
There was no direction. Lord, I will only make submission of law, and it is possible, my lord.
To kindly give the direction also.
You also working in primary school.
That information I do not have. The client.
All after thought.
No,
Whether we
that
shall
is
initiate
already been allowed.
agitation, whether we shall
Yes,
accept it or
one
not.
order to your lordship has
Are
been
this
allowed.
the diary that it is for the applicant?
Fourteen also there is similar matter, item number 11 and 12. And in this case also it's been directed for affidavit in opposition. Still they are not filing, my lord. And 11 and 12. Well, same
When did we keep it? এটা কি 19th তারিখে?
19th.
I done it, I reply to our opposition.
Yes, my lord. I have.
Already you exchange in the meantime, it will appear on 9th. একটু ডাকো 14th.
And our budget.
Coming. Is the reach petition?
No, the reference. But
Delay of how many days?
I'm for
Delay is
the,
there. Delay is there.
no, I am praying for stay of the operation of the order. Because by this order, on the single judge as well, there is no existence of the council as a body itself.
No, only computer again. This was placed before us when we were hearing that proper primary.
Probably orders was shown to your losses.
September 2020. What stay do you want after 6 months?
Stay of the operation of this.
Any point in time?
Transfer order quashed. Respondents are directed to allow petitioner to continue the treatment.
But your losses kindly see the findings before that. Page 45, paragraph 45. I think they will not oppose the stay because their purpose is served. Transfer has been caused and he has been placed accordingly.
Oh, I see.
That's why nobody is eager to do that. But it's a body man. Now, if the body doesn't exist, the entire system under the act will collapse.
This was on evidence, Mr. Shan.
No. Before on the basis of the report. Finding the point of law. Simply. No factual involvement was there. Except whatever we admitted by the court. This findings creates problem throughout the state. But the paragraph 46 that has been carried out. Right? This is very well
Dismissed on the ground of lack of jurisdiction. Interpreting just an observation devoid of competence to issue. Chairman.
That was in respect of order of transfer.
Yes.
But by doing this, the point was raised that there is no existence of the council, and that has been decided.
No.
Yes, paragraph 45 if you lost
statutory command of section 37 being mandatory. Absence of gazette notification leaves the council without legal existence in it.
Now that's the according to us, the learned.
Yes, for time. What instruction, madam? You're working there, your transfer order has been quashed. They are seeking this observation has to
non-existence of the council. That should be stated. But even the order has been carried out by the same council.
This has been said by notification. By notification, most probably there was no notification.
There was no notification, Mr. Sharma.
Well, I tell you, notification was there, Super Chair, but that was misleading or misconstruing the section itself.
So there was no notification.
Notification are not required. I take your losses to that. Section 37. Just your losses.
So if we admit the appeal, question of finality of that observation.
No, because you kindly have a look at page paragraph 45.
Yes.
Therefore, the statutory command of section 37 being mandatory, absence of valid gazette notification leaves the district primary
council without.
We will incorporate that as the ground of appeal.
Yes, yes, we have. We have taken the ground.
This issue will be decided in appeal. What stage you are?
Oh, then your losses kindly. The doctrine of lifting the veil corporate compels the recognition that the individuals describing themselves as functionaries cannot, in the teeth of law, bind a non-existent statutory corporation. They realize the particular, therefore the impugned order cannot be permitted to stand. So finding is that the council does not exist.
No, no, no. Doctrine of lifting the corporate veil compels recognition that individuals describing themselves as functionaries cannot, in the teeth of law, bind a non-existing statutory
Exactly.
corporation.
Therefore, holding that the council is non-existent body. Or your lawsuit, my lord, may I your lawsuit? Operation of this status quo in regard to the operation of the council as a body. Because court holds there is no council.
That has not attained finality. We are in scene of appeal.
No,
That does not render legal action.
Unless your lawsuit gives some interim protection, that will be big difficulty for the council.
We will decide this issue. We will say that we will decide.
And today, whatever function is done with the in the light of the law, in the teeth
It
of
will
the
not
order.
be bad since we are deciding this. If such situation arise, you can come with an appropriate appeal.
Listen, as of today, by virtue of these judgments, council doesn't exist. And everybody is showing this judgment. Even the order has been carried out by the same council.
Agree by the observation made in 45. Observation এখানে 37 comments, a publication of a notification. It's misconstitution.
Cannot be permitted.
এটাকে stay করি আবার এইটা
They are not bound to comply with this.
কিন্তু ওরা comply করে।
No, we have complied with the order. We have.
If we stay the proposed observation in para 45,
Exactly.
it ends with saying, therefore, the transfer order is valid.
No, your lordship, no, not that, your lordship, status quo in regard to the functioning of the present council. That we are, but because this order has been carried out by the same council, by the same chairman. If there is no council exists, there cannot be any chairman. Logical conclusion. You will see every time they pass directions upon the chairman of the council. Even today, we are carrying out. It will be a deadlock situation. Asking for difficult.
Where is your senior, madam? Very difficult. Every matter, my senior is there, my senior is there. 18. Who sits in 18, madam? Do you know the name of the judge in 18? You do not know. You are prompting it as you heard from her. বিরক্তি লেগে গেল। Who sits in 18? So that is a division bench.
The functioning will be difficult.
Not today, Mr. Come tomorrow, Mr. Yes, but
I got one line order. One line order that on their clear this is adjourned for the day. Your losses will be low. Your lordship, no, I wanted to do even before recess. Your lordship just we are coming. I was under the impression your lordship will come up within 5 minutes. Your lordship, 2 or 3 occasions.
So
We came within,
wait,
we came within 5 minutes to 5.
That was after recess. So your lordship rose at 1 p.m.
Yes.
So I thought just you will come up, your lordship will come back. And then-
So we have, yes, next.
Yes.
Order number 16.
15.
And what is petition?
Again, out of time.
The matters can reduce from my list usually.
Order number 17. I am appealing, my lord.
17.
My lord. Yes, right. Jessica, my lord, my lord.
Oh,
My lord, please help me. Need to part. My lord.
My lord's order.
My lord.
order issuing, order issuing in the appeal has been passed. By one. The appeal stands released formally.
The commission in item 8.
Order number 18.
You are,
I'm appealing for the commission in item 18.
you are for the application for leave to appeal. That is half.
Yes, was taken up on the last week, my lord, because adjourn on the ground that the father of Mr. Shamu was not being just not for natural.
And my senior is just on the way with becoming something for a short person.
You start what is the matter?
The petitioner or the applicant before your lordship seeks to challenge an order dated 19th of November 2025.
Where is your application for leave to appeal?
Can one is leave to appeal, my lord?
No, can one is late.
Can two.
And
Just tell us what is the story.
this is given once of the petitioner is valid. Petitioner was working as a teacher in respect of the recruitment process which was initiated as performance of the first HLS. The applicant before your lordship is a physically handicapped man. He has some physical disability. Now, my lord, in our reading, my lord, the judgment which was delivered by the Honorable Apex Court, Shaki Bhattacharya, if your lordship kindly sees the paragraph 48 and 49, my lord, liberty was granted to the candidates who were physically handicapped, that they would not be given the employment, but they will be allowed to seek for the examination, irrespective of the result, whether they are tainted or untainted. And that Order that,
irrespective of printed and unprinted.
yes. And then that finding,
Then why, what was the writ petition about?
the writ petition was filed by certain unsuccessful candidates. Their prayer was not related to any prayer relating to any physically orthopedic or physically handicap or physical any needs
They were physically handicapped.
No, they were unsuccessful candidates. Their ground was that certain persons who were tainted, they have been incorporated in the list and they have been called for interview. Your lordship will be finding the order at page 177.
The court called for publication of a list. Then
Your lordship kindly comes.
now the writ petition is pending.
Writ petition is pending.
Yes.
But in terms of disorder ballot, my candidature in the second ballot recruitment, it has been debarred. I have been debarred.
No, the list you featured in the
I
10th.
featured in the 10th list, my lord.
Very good.
And
So you have not been allowed to appear. Now this you are tainted that came to your notice after publication of the list in terms of this order.
my name was initially there in the list of 952 candidates, my lord. That was
952 what?
in 2020, the list was published, my lord. The
Was it?
OMR mismatch, my lord.
Pardon?
OMR mismatch.
This is of upper triangle.
No, class 9 and 10.
Yes.
Sir, what has happened to me? I appeared in the first HL. I was given employee. I was serving. Thereafter, a series of orders was passed, my lord.
In first
First
RLS
HLS, yes.
that is held in the year 2020. When was it held? First
2016 selection.
26. So why you are saying 2020?
No, 20.
So you were a physically handicapped candidate. All of you.
No, only one candidate.
Achha, you are physically handicapped. You appeared in first SLST in 2016. You got recommendation and appointment. Thereafter, by virtue of Boishaki's order, you
My
got
appointment gone.
appointment gone. Now you are not being allowed to participate in the. You are not being allowed to participate in the.
Second recruitment process, my lord, which was initiated in terms of the order of the Honorable Supreme Court, my lord, in terms of this order at page 177.
Where is that direction? 177. Where is that you will not be allowed?
And page 180, my lord, internal page 4, paragraph 11 onwards.
So two candidates were allowed.
Yes.
Then
Paragraph 14, my lord, next page.
so you are not similarly situated with Somadas. Yes, senior. Then
Yes, my lord. My contention is that with regard to this fragmented, my lord, determination of the writ petition. Writ petition was something, and thereafter a order is
which observation is against you?
well, this observation with regard to
You made an application for addition of party.
no, because this order itself, even if I make an application for addition of party, my adding myself in the repetition would be of no use in view of the fact that already this order has been passed where my rights have been
So go and explain that to the single judge. File an
subsequently,
application for addition of parties.
subsequently
Read petitioner is not agreed by this order.
we are agreed
So
in view
your
of the fact.
observations, read petition pending. File an application for addition.
Now, my lord, in the meantime, my candidature has been cancelled. I have
Speak
been
appropriate order in the read.
now, my lord, the interpretation of paragraph 48 and 49 of the Boishaki Banerjee judgment has been, my lord, conclusively, my lord, arrived at by the honorable trial judge.
Where?
Now, my lord, it will not be, my lord, paragraph 11 onwards. My lord, the writ petition was for a different prayer. Writ petition is pending. This has happened in other matters also, where the writ petitions are being kept pending and a fragmented part of the writ petition is being determined and adjudicated, which is in effect affecting the rights of the persons who are not even parties or even parties. That is my observation.
Show us that specific. We will not read 8 paragraphs.
No, of course not. Now, kindly pass these.
Where is the writ petition?
Writ petition is not correct.
What is the prayer in the writ petition?
It's not annexed. We are not party.
Yes. What was the writ petition about?
Maybe I read they are I just to direct the investigation regarding alleged manipulation, including tainted candidate in interview list or other. What happened?
Now, please read. You're reading. It's not.
And read. So read of or in the nature of mandamus directing the respondent, their agent, servant, subordinate, to publish all OMR sheet in connection with first SLST 2016 and second SLST 2025. And next one is cancel, set aside, assign or modify the interview list published by the respondent commission in connection with second SLST 2025.
That
Next
second
one.
SLST means when
It is going on.
It's going. According to orders of the honorable Supreme.
But each one of them to prepare and publish a fresh interview list, excluding prior teaching experience.
very good. Now in this order,
I do not accept it because it is not authenticated. It can be.
what do you madam? Who is speaking?
Oh, somehow, some other. Then next prayer is that to publish interview list and all tainted candidate list along with all details, including father's name, category, address, and other. Because of that, publish all tainted candidate list. So it's my to publish name of all tainted candidates, including the candidate who got appointment after expiry of the panel, rank jump, and other categories. The next prayer is that it is to call the petitioner for document verification and interview process, that is to conduct in camera interview process.
So this person, the petitioner, was a handicapped person?
No. What happened? No. Then the candidate participate in a selection process which is conducted after the settlement of the first SLST 26. What happened, man? The Central School Service Commission, they tried to accommodate all tainted candidates first. Thereafter, they failed to do so. It's my submission, sir. After that manner, because of that manner, the court order, they precluded for sitting that tainted candidate. Thereafter, they tried to give a pathway to the physically handicapped tainted candidate, which I referred in this petition. Look, in the interview list, there are several tainted candidates. Thereafter, the School Service Commission says they are the physically handicapped tainted candidates.
Very good. So that point is yet to be decided.
Well, it is correct.
That point. That point has not been decided. Court has called
Because
for
of that, what happened, Malad, in the meanwhile, Supreme Court passed this Vivek Pariyar matter, and in this matter,
Malad, paragraph 1, he is an unsuccessful candidate.
Malad, kindly see
Of the impugned order.
Supreme Court order, what Supreme Court said by putting this Musumi Mondal writ petition number specifically. Malad,
what did the Supreme Court say?
Malad, kindly turn page number 7.
So why didn't you tell this to the learned single judge?
All it is still that
Then what you are saying to us? Court has said only let the list come. You are not agreed by the order. Why we will go into this order?
because my understanding says
He
because
has not yet advanced his argument. Yes, what is your argument?
Malad, my contention is that the scope of the writ petition is totally different. But in that writ petition, Malad, it has been preferred admittedly by a person who is
Achha,
unsure.
so which observation?
Paragraph 11 on
11 onwards.
further been submitted that two candidates being such and such.
Where you are reading?
This is the submission.
Paragraph 10 you are reading.
Paragraph 10, internal page 4 of the
Yes.
impugned order. In terms of the relaxation provided in paragraphs 48 and 49 of the judgment dated such and such, the commission permitted the above aforesaid two visible candidates to participate in the recruitment process despite their names being reflected in the tainted list. My lord, I am circumstanced with these two persons, similarly circumstanced, because I am also a visible candidate. The name of the other two candidates mentioned in paragraph 14 are not properly spelled accordingly such and such. Can thereafter, so this is the position. Now kindly see what is being held. Paragraph 14. Upon hearing the submissions made on behalf
What are these two applications in paragraph 13?
these are one of the applications.
Similar application for addition of parties,
Yes.
like you.
Yes. Submitted that since recruitment process is conducted, the direction, the instant recruitment may not be entered, which was their submission. Upon hearing the submissions made on behalf of the parties and on perusal of the materials placed before the court, it appears that the Honorable Supreme Court made it explicitly clear in paragraph 48 of the judgment dated such and such that apart from one candidate, Soma Das, other differently able candidates will not be entitled to the same benefit as given in the case of Soma Das, as it would contradict the legal principles and rule of law. However, considering the disability to candidates may be permitted to continue and will receive wages until the fixed selection process and appointments are complete. In paragraph 49, clearly laid down that disabled candidates will be allowed to participate in the fresh selection process if required, with age relaxation and other consequences. Similarly, other candidates who are not specifically tendered will also be eligible to participate in the appropriate age relaxation. My contention is that I will be able to participate, and I have participated. I was allowed to participate. On such and such, the Honorable recorded the submission of the commission that none of the tainted candidates will be permitted to appear. The court also took note of the submission of the commission that he makes tainted candidates.
Then what is against you?
Well, this paragraph,
Which paragraph?
this 14,
Yes.
and paragraph 20. Paragraph 14, I have already placed, so therefore I will not repeat. Paragraph 20. On conjoined reading of the orders, Ashwin is there, paragraph 20. Passed by the Honorable Supreme Court on such and such and such and such, it appears that the candidate whose name appeared in the tainted list, irrespective of the disability, cannot be permitted to participate in selection test conducted by the commission. I am a disabled candidate. My name is also appearing in the tainted list.
No,
But
then why the fresh tainted list has been called for?
that, my lord, they are according to their contention.
Court directs the commission to file fresh tainted.
Yes, that is by my lord, by disclosing the particulars for identification of candidates. Paragraph 33, Roshav is talking to this. Roshav is my lord
36.
33, I think. Paragraph directions containing paragraph 33. Roshav is probably referring.
There was already a tainted list.
Yes, that is subject matter of challenge in different petitions.
Now in that tainted list, your names feature.
Yes, but I was allowed to participate in the recruitment process since I am a disabled candidate. Now this honorable
On the basis of Supreme Court's decision,
Yes.
paragraph 49.
49.
Soma Das.
Not Somadas. Somadas is the person concerned. Who is
You are similar to Soma Das.
I am not similar to Somadas. Somadas was a cancer patient. I am not similar to Somadas. I am a disabled candidate.
So para 49 said that Soma Das and similar persons are excluded.
No, paragraph 49. May I just paragraph 49.
Other disabled will not be excluded. 49 says that apart from Soma Das, nobody else will be allowed.
49. Disabled candidates mentioned in the previous paragraphs will be allowed to participate in
Wait.
Okay, let us read paragraph 48, 49.
40. Yes.
Yes. Yes, please.
48. Lastly, we address the case of disabled candidates. Our attention has been drawn to one such case where the interim judgment held that the appointee Mrs. Somadas shall be allowed to continue humanitarian grounds, which was there in the division later. While we will not interfere with this finding, we make it clear that other differently able candidates will not be entitled to the same benefit. Means they will not be entitled to continue. As we coincide with the legal principles and rule of law. However, in consideration of their disability, the candidates will be permitted to continue and will receive wages until the fresh selection process and appointments are complete. Paragraph 49. The disabled candidates mentioned in the previous paragraph will be allowed to participate in the fresh selection process if required, with age relaxation and other consequences. Similarly, other candidates who are not physically tainted will also be eligible to participate with the appropriate age relaxation. In our opinion, such direction will be fair and just and would allow these candidates to take part in the selection process, which should now be initiated.
What does the first three lines mean? The disabled candidates mentioned in the
previous paragraph.
which paragraph?
48.
So 48 said apart from Soma, nobody will be allowed.
However, in consideration of their disability, these candidates will be permitted to continue and will receive.
The disabled candidates mentioned in the previous paragraph, that is 48.
40. Disabled candidates
will be allowed to participate in the fresh selection process if required, with age relaxation and other. So the
Somadas was allowed to continue. Somadas' appointment was not interfered. Other disabled candidates, their appointments were interfered and they allowed, but they will be continuing in this fresh selection process and they will be allowed to participate.
That allowed to participate where do you find?
The paragraph 49. Disabled candidates mentioned in the previous paragraph will be allowed to participate in the fresh selection process. If required, with age relaxation and other consequences.
First three lines is not clear to 49.
49.
Disabled candidates, it is plural. Candidates, plural. So, disabled candidate mentioned in the previous paragraph. So, in the previous paragraph, thus Somadas was referred and
be allowed to continue your humanity.
And
appointment cannot be.
Yes, and
while we
considering the disability of certain candidates, are permitted to continue and will receive wages
Yes,
until the fresh selection process or appointment are completed.
yes,
Whether this disabled candidate refers to this candidate,
yes. We were the disabled candidates. I am also a disabled.
it is your interpretation.
No, I am a disabled candidate. The
It
previous
is
selection.
your claim.
No, I am, please admit. In the previous selection process, I participated as a
Now, in
disabled.
the disabled candidates mentioned in 48 is what? Somadas, separate?
Somadas continue apart.
So those other disabled will be allowed to continue and receive wages till fresh selection process and appointments are.
We are continuing.
So where is the direction in page 48, para 48 that you will be allowed?
Paragraph 49.
Acha, that according to his paragraph. Para 49 begins disabled candidates mentioned will be allowed to participate if required with ages.
It was also the interpretation of the commission as recorded in the.
Now what did the single judge say?
Now kindly reads paragraph 20. On conjoined reading of such and such calculate the candidates whose name is
Which is this order? 3rd April and 29th August? This is the order. 3rd April and 29th? What do you put there?
yes.
দেখুন এখানে আজকে আমরা কন্টিনিউ করছি পুরোটাই ক্যান্সেল হয়ে আর যারা তারা কন্টিনিউ করবে until the selection process and appointment.
এখানে বলছে other different will not be entitled to same benefit.
Other disabled
মানে
benefit মানে which is given to সমাজ অর্থাৎ to continue. কিন্তু এই যে disabled
not only to continue, but Somadas cannot be sent out of employment. যেহেতু not affected.
Not affected. Even in considering their disability,
will not be entitled.
Their candidate will not be permitted to continue and receive a civil candidate.
Till appointments are completed.
এবার এদের নিয়ে কিন্তু এই সিলেকশন পরীক্ষা দেবে
Similarly, others who are not specifically tainted will be eligible to participate. This specifically tainted does not appear in para 48. এখানে একটা নতুন clause।
এদের আধার ক্যান্ডিডেট তাহলে মানেটা দাঁড়াচ্ছে
Yes, what will be single gender? Yes, para 20. That just can cannot be.
This order is this order dated
commission 3rd April.
This order 3rd April.
Paragraph 23. Understanding of the commission that differently abled tainted candidates will be permitted to participate in the selection process does not appear to be in line with the orders passed by the opposition.
Yeah.
Here I am.
That is why court went on to the extent of granting liberty so that the commission may take them.
Yes.
Granted by the
necessary action and my candidature has been cancelled.
25 and 500. Maybe the understanding of those only to restrain participation of any tender, whether different or not. Yes, which were the commission?
Commission Rahul is there.
Online.
Lord, I'm appearing online for the commission.
So Rahul, Rahul Singh, Rahul Kumar. Rahul Kumar. That is why they have passed. They allowed us to pass.
Now, what had been the progress in the printing read? Now the tented, untented list has been filed.
Yes, although this is there, I believe they will be.
And it don't make a
Against this order, West Bengal Central School Education Commission directly prepared an
SLP.
and that SLP, the order was very specific against this particular order. I read that, I believe is fully agreed with this order.
Mr. Bhattacharya is appearing. Mr. Bhattacharya is appearing.
Look, I am appearing, look, kindly see the order passed by the Honorable Supreme Court on 26th of November 2025. That makes the position clear.
Page 180.
Page 188.
Yes.
The relevant portion is at page 189. After recording that the judge is hearing, then the court records, High Court shall, however, ensure that none of the tainted candidates are permitted to slip through in the fresh selection, be it on any pretext. High Court shall also ensure that the list of tainted candidates is placed in the public domain with full details so as to ensure that this does not happen. Therefore, this is the final order which the Supreme Court made clear, no tainted candidates of any category would be allowed to participate.
Now, what about publication of the list?
That is also insisted upon, and just directed them to publish it. That's also mentioned in the order.
So you were also agreed by that direction.
We are
You are
asking,
not the commission. Sorry.
we are asking for the commission had preferred SLP, not we.
But we have only preferred SLP with regard to the interpretation.
Interpretation of what?
So whether the disabled candidates will be eligible or not. That interpretation was not interfered with by the Honorable Supreme Court. And after that, on 14th and on 28th of January, we have published two separate lists of tainted candidates. Even those who were not appointed by the commission in the first SLST, but whose names featured in the CBI's list, even their names were also published by the commission as per the directions of the Honorable Single Judge.
Now,
Therefore,
Mr. Bhattacharya, this observation, High Court will have none of these slips through.
Yes.
This was there in the parent order also.
Yes, but that's why the High Court, the Supreme Court clarified. The question arose whether the disabled candidates, irrespective of being tainted or not, would be allowed to appear. That was the order. Then the Honorable Supreme Court made it very clear that none of the tainted candidates. Supreme Court said our intention is tainted candidates should be completely kept out of the new selection process. And the publication of lists, now the SSC has published some certain list. Though
But
we might have...
This observation, apparently subject to correction, of the Supreme Court observation will not ensure slip through in the selection process. Then why did Supreme Court say in paragraph 49?
No, but that was explained. My lord, if your lordship
Paragraph
reads,
also kindly reads in that
if
order.
my lord
Paragraph
reads,
49, Mr. Bhattacharya, Supreme Court says that similarly,
my lord, Supreme Court has clarified that direction by subsequent order. That
That is-
Supreme Court wanted to ensure that no tainted candidates.
All are into application, everything is missed.
So we don't want to sit in appeal over the order.
The High Court shall examine the same matter. Kindly sees the order which has where
what can
don't
we do, Mr.
invite us to sit
paragraph
in appeal.
page
Mr. Light, you have this direction.
Yes,
kindly read them.
Oh.
High
Go and tell
shall
to the learned
examine the
single.
matter.
Eh?
Kindly read it. Special leave petition is disposed of on the aforesaid terms. High Court shall examine the matter uninfluenced by the observation made on merits by this court in the order passed after the decision of Boishaki Bhattacharya. So Boishaki Bhattacharya will only remain. Nothing after will be. High Court shall also be mindful of the fact that untainted candidates in the past election process were allowed to seek for selection to be held afresh, and their candidate cannot be adversely affected by the application of the new rules, that is the West Bengal such and such rules 2025 pending applications if any self
In
so
view
therefore
of second paragraph, in view of the second paragraph, Mr. Lighty, what
Yes.
can we say?
shall also ensure that list of now kindly see the next line.
Ensure that none of the tainted candidates, admittedly you are a tainted candidate.
Next line Supreme Court says High Court shall, then the High Court will be influenced.
Go and tell
By
the
the-
Yes.
Go and tell them.
Mr. Lahiri, one thing.
This is
Since this order,
both the impugned order. So
Mr.
Lordship
Lahiri-
remands back the order, remands back the matter to the honorable single judge. so that
No,
he can
no,
File an
no,
application. We will dismiss the leave to appeal. Or you withdraw and file.
Fine.
We will not dismiss.
Mr. Lahiri, since the Honorable Supreme Court has considering the order not to be challenged in this appeal,
Yes.
on which you are taking leave,
Yes.
has passed an order.
Yes.
Whether it would be justified for ours to sit in appeal over that order.
The honorable, no, I'm not praying that Lordship will be, how can I pray that?
If
But
we cannot, Mr. Lahiri, if we cannot entertain the appeal, can we grant leave to paper appeal?
Lordship can entertain the appeal in view of
Why you are
statement
wanting an
observation.
observation? Why you want to make things more complex?
Yes.
But my candidature is being published.
File an application. File an application for addition. Have your point heard out.
But this order will be there.
Which order?
This impugned
This
order.
you will explain to the single judge that this order which has been passed according to our understanding and argument, these are the flaws. Point it out to the single judge. Why
And
you
my
are
lord, so Lordship may also my lord, makes it, my lord, I'm not going.
pending petition pending.
That is the point, my lord, the petitions are being kept pending. I fail to understand.
এই অর্ডার এইরকম 19/11 আর এই অর্ডারটা 19/11 অর্ডার যেটা চ্যালেঞ্জ করতে সেই অর্ডারটা কনসিডার করেই অর্ডারটা
হ্যাঁ, that Supreme Court subsequent order was on this particular order.
Now it has now kindly the High Court shall examine the matter uninfluenced by the observation on merits by this court in orders passed after the decision of Boishaki.
That
So
is
therefore, any
that-
order, 1 page, 2 page orders that the Honorable Supreme Court has passed, Honorable Supreme Court has made it clear that whatever we had said in Boishaki Bhattacharya will be followed. And the High
and
Court
that is
proceeds
clarified.
Let that be understood by the single judge. Why you are coming to us?
Then my lord kindly clarifies that. to
No,
the-
why should we? We will dismiss.
Otherwise, if
We
it
will
is
dismiss your
no,
leave.
my lord,
leave to appeal, we
It is your choice. If you say I am withdrawing, you go. Or you say we have expressed our mind, we are going to dismiss your application, subject to what you have submitted.
then well, I will not be having any other place.
Why?
If Lordship is giving me liberty to go back to the Honorable Single
We will
Judge,
say you are dismissed as withdrawn with liberty to file appropriate application before the.
my lord, then my lord, then it will be difficult. Well,
Then
we'll
no,
not
no,
do
no.
that.
Suffer our order.
Because
order.
because if your lordship's if lordship gives one line so that I can go and approach the Honorable Single Judge, lordship is determining leave to appeal, not the appeal. So Lordship is of the view that
We are not of the view. We are saying you are withdrawing the appeal with liberty to file appropriate application in the pending writ petition.
agitating all the points.
Naturally,
No.
you will not write points.
No.
On the prayer of Mr.
May I
Lai,
take one day instruction?
No, 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 no.
on the prayer of
The day he is not having instruction.
Mr. Lai, you are not considering, you are not.
And clients will say that I have not instructed. Why did you?
So why didn't you take the instruction, Mr. Lai?
Instruction.
But a senior advocate, you don't know. At this point, will be asked. Court may insist upon us to withdraw and go before the single judge. You are a senior.
Everyone will remember everything. For that instruction. Otherwise, he will be. Clients can come and say that.
Then to be mentioned tomorrow or we dismiss it?
Tomorrow. No. In that
No,
case,
no, sir.
that the
No,
instruction
no,
will
no.
come.
You take instruction. It is a leave granting. If you don't say, if you want to say that I will not withdraw, we will pass the order.
Then
What is on the prayer of Mr. Lighting and the advocate appearing for the applicants, the application for leave to appeal, being such and such, is dismissed as withdrawn, with liberty to file appropriate application in the writ petition pending before the learned single judge. In view of consequently, the appeal is also appeal and the connected and the other connected application are also dismissed.
Deeply obliged.
Being not appeal.
As a consequence, sticky আছে তো।
This civil
Order
court are that everything has
upon
been
instruction on the prayer of Mr. Lighting, learned senior learned senior advocate appearing for the appellants. Applicants on the
with the liberty of Lordship.
yes, with liberty to file appropriate application in the pending writ petition before the learned single.
Otherwise, the next point will be there.
Deeply obliged.
Yes.
Grateful.
Present one copy to Mr. Swami.
He has more than me. I have 2 years to work.
Yes.
By this time,
You made us almost mad with the 32,000 letters. In my chamber, there was a pile of files. Yes. What happened to your SLP? What happened to your SLP? You have gone against the order. What happened? Hurt. You're waiting for an opportunity. Yes, next one.
Item number 19.
Election dictator.
When the time playing for not today, Well, this matter I'm saying for not put a matter.
And I'm appealing for the commission. Copy may be served, my lord, in this matter.
You have not served copy upon the commission.
I have no knowledge about the matter because Shankar Prasad Kalapati appearing in this matter. Due to some personal difficulties, he did not come to the matter.
But copy is not available in Sharthak as well, so we cannot access it.
Delay of how many days? 10 days.
So the order was passed in November. It's again a tainted candidate whose name appeared in tainted list.
2 weeks. Third complete service. You have got the state. You have not got copy. No, I have. Okay. 10 days. No, I don't know. Do we service not section 5 not given to you?
Section given to you.
We will not object to condonation of delay.
I agree with this. But unfortunately, I have also missed my brief. But it is those set of matters, my lord, where you
Only we do not miss our briefs.
I am very unfortunately, my lord, I am candidly submitting. But it is those set of matters, my lord, where the tainted candidates, allegedly tainted candidates, have filed the petition, seeking to have the right of participation in the fresh selection process. This is more or less the feel and substance of what is it. But I will address your lot in this matter. But I kindly takes up any day.
2 weeks. There is no scope for interim order.
There is no scope for interim order. At the same time, my lord, your lordship takes up any day continuing to your lordship as your lordship.
No. Then we will ask them to exchange their evidence. Affidavit is required.
The issue is settled by your lordship's order dated 4th of September. Your lordship has decided this issue, my lord. On 4th of September, the name of the candidates appeared in tainted list. Appeal was preferred by before your lordship against order dated 2nd September. My lord, your lordship was pleased to dismiss the appeal, or even Honorable Supreme Court was pleased to dismiss the appeal from the single benches order. My lord, it was preferred directly.
I am bereft of.
We will place the orders, my lord.
He passed an order dismissing the petition.
My lord, the Honorable Single Judge dismissed the writ petition on 2nd of September. Latest patent appeal was preferred before your lordship, my lord. That was dismissed from the single judge's order, my lord. And SLP was also preferred, which was dismissed on 12th of September. My lord, the LP order was not carried in appeal.
Take down those orders.
Yes, my lord, I have just requested my learned to have those.
But I will communicate all those orders, my lord, my learned senior.
All right, sir. May it be after 2 weeks.
Mr. Choudhury, learned advocate appearing for the appellants, submits that service upon all the respondents are not performed. In view thereof. But it is order declared before.
But let there be a notice.
2 weeks. 2 weeks, madam.
But if your lordship does not pass any order today, but I would be having a predicament in serving the GP's office. Since the delay has already been occurred in serving, but I have gathered from my learned. The GP's office probably will accept service. Have the full correction, madam.
Then orders are passed.
Mr. Choudhury, learned advocate appears for the appellant, submits that service upon the state respondents is not common. State respondents. Ms. Bhattacharya, learned advocate, and Mr. Singh, learned advocate, entered appearance on behalf of the board and the commission. This is the matter for further consideration on 24th February. The appellants have rejected to complete service.
So very good.
And file an exempted service.
I see it. Unconditional approval.
24th February.
Item number 20.
But my the opposition, they type of
Twenty-one. Twenty-one.
India's wanted therefore that the epidemic opposition which has been formed by the Prime Minister Council was submitted before the Civil Judge. When I gathered the information, it was not submitted.
My Lord, I got the district prime minister to come. My Lord, affidavit in opposition was, my Lord, it was affirmed, but it was not passed. But my Lord, when the matter was called on, without affidavit, my Lord, the matter was disposed of by the Honorable Senior, and order it will pass. Therefore, the original affidavit in opposition is tied with the affirmed petition. Because of that,
read code.
Before the read code.
Read code you did not fight.
My Lord, no, I was under I made a prayer before the court that matter may be, my Lord, not giving some, allowing some time for 5 weeks. But court, my Lord, disposed of the petition without, my Lord, taking into consideration the affidavit of opposition, and I did not file. And my Lord, matter was disposed of.
Whether the affidavit in opposition was made part of record by the
It was not filed. It was not filed. It was
so although we are keeping it, your supplementary affidavit on record, but sorry, we shall not be able to look it.
very good.
Since the learned single judge did not consider it,
yes.
How appellate court will consider? Yes, he places
Supplementary, you annex the evidence.
affirm করেছে কোর্টে দেয়নি কিন্তু
It was served upon us. It was served upon us.
Considered by
part of record considered by the single judge.
So what is your prayer?
Now, today,
what do you want? Yes.
I want, my Lord, the matter will be heard, my Lord, as your Lordship desire. If it is your Lordship directly to file here and now, I can file. Otherwise, your Lordship can dispose it up, my Lord, as the, my Lord, order passed by the Honorable Single Judge. Your Lordship can dispose it up.
Is there the order of dismissal which has been passed by the court, single judge?
Lordship.
Do you want to justify that order by placing reliance upon any document from your opposition?
No, my Lord.
No.
Everything, my Lord, I have submitted.
Oh, then there is no further requirement. Then we can,
according to my Lord.
But you want to rely upon?
You file a paper book incorporating all those documents just served upon.
It can be disposed of if you also send this to the order of the order of the trial judge. The lordship can be.
There is no scope for interim order, Mr. Bhatt. Then we are finally hear the appeal.
Yes. you'll also see the page 71 of the application.
Yes.
The petition number 2 is the son of Group D staff of the government aided secondary school, who is desirous to be appointed on compulsory ground. Since the petition number 1 being the mother of the petition number 2 has been declared physically incapacitated by the competent medical board and was allowed to retire voluntarily on 17th December 2012. According to the repetition of voluntary retirement of the petition number 1 effect from 17th December 2012, on being declared physically incapacitated, confers the right upon the petitioner to be appointed on compulsory ground in terms of the retirement circulars and rules applicable at the material point of time. Mr. Bari, learned advocate appearing for the petitioner, submits that the application was made by the petitioner number 2 for appointment of a primary school. As a result, the matter was ultimately referred to the chairman of the concerned district primary school council for taking a decision pursuant to the order dated 2nd December 2015, passed in the petition being WP number certain. Such order of the coordinator at page 41 of the petition being unaccepted. Pursuant to such order dated 2nd December 2015, decision has been taken by the chairman of Western District Primary School Council by issuing memo number 16 February 2017, whereby it was communicated to the petitioner that in view of provision rule 14.2 of the West Bengal Primary Teachers Recruitment Rule 2001, being applicable only to the primary teachers, not applicable to the group D employees of the high secondary schools, no benefit of the such rule can be extended to the petitioner number 2 hearing. Mr. Ranjan Sal, an advocate appearing on behalf of the Western Bengal District Primary School Council, submits there is no post of non-teaching staff's primary school. For appointment of the assistant teacher in the primary school, a candidate needs to be trained. Therefore, petitioner not having requisite training qualification is not entitled to be appointed to the post of the assistant teacher in the primary school. This court has considered the direct submission made on behalf of the respective parties and also the decision of the chairman, Western Bengal District Primary School Council, containing the memo dated 16th February 2017. It is true that apart from the non-applicability of the Rule 14.2 as per the Primary Teachers Recruitment Rule 2001, in the case of the claim of the petition number 2, the petitioner is not a trained candidate. Therefore, it is impossible to appoint the petitioner in the post of the assistant teacher of a primary school on compassionate ground. Therefore, it appears the decision of the chairman, Western Bengal District Primary School Council, dated 16th February 2017 is not clouded. Fact remains the petition number 2 claims the appointment of compassionate ground since his mother was declared physically incapacitated and was allowed to retire voluntarily on 17th December 2012. As it appears, since the petitioner to apply for compassionate primary school chairman concerned district primary school council took such decision. However, it was open to the petitioner to apply for appointment to the secretary school in a post commensurate with the educational qualifications. Since the division of the chairman concerned district primary school council dated 16th February 2006 appears to be correct, then it is stand dismissed. However, this order shall not prevent the petitioner to make an application for appointment on compulsory ground in a secondary school in terms of the West Bengal School Service Commission selection person's appointment to the post of non-teaching post 29. If such application is made in terms of the said rule, the responding authorities are directed to consider the same according. This is the order passed by the single judge. Now, my lord, twofold submission I am making. One, the rules prevailing at that point of time. To show at that point of time, court says that my case will be considered rules prevailing at that time. The earlier process, court said. That was not challenged and same as gone finally.
Where is that order?
Well, at the page 64. Well, this is the order, page 64. The lead petitioner seeks appointment on compulsory ground is permanently incapacitated on medical ground category. The petition number 1 was a group D employee of the secondary school. He had applied for voluntary retirement on medical ground. As he was not in a position to render her service due to various elements, her application was subsequently accepted. This petitioner number 2 has applied for appointment on compulsory ground. Such application, however, has been rejected by the chairman of concerned council on the ground that he does not have the required qualifications. It is contended on behalf of the writ petitioner that the rejection of the impugn order dated April 1, 2015 is incorrect, as the chairman had taken into consideration the government order dated 25th February 2014, which is not attracted to the facts of this case. Under the government order dated January 28, 2008, an appointment can be given to a person who is a school final or Madhyamik pass. The second writ petitioner is a graduate. Therefore, he meets such educational qualification of requirement. His application is required to be considered according to law. The council authority states the present. I find from the impugn order April dated 2015 that the chairman has negated the claim of the second writ petitioner solely on the ground he does not meet the required qualifications for grant of appointment. This finding of the chairman is incorrect and cannot be sustained in view of the comment order dated January 28, 2008. Such comment order applies to the fact in the case the first writ petitioner had made an application for voluntary retirement on December 17, 2012. She was physically unfit for service and was allowed to retire voluntarily on December 17, 2012. Consequently, the government order dated 25th February 2014 is not attractive, as the entitlement of the second writ petitioner to apply for compulsory appointment had occurred on December 17, 2012. In such circumstances, the impugn order dated April 1, 2015 is set aside. The chairman will consider the application for the second writ petitioner in accordance with law, preferably within 4 weeks from the date of communication of this order. Needless to say, the chairman will take into consideration the law applicable to the petitioner as on the date of making application. This is very important. As on the date of making applications, being April 13, 2011, the chairman will afford a reasonable opportunity of getting writ petitioner prior to passing of his order. He will communicate the reason order to the writ petitioner 4 days thereafter with this observation of the action is such and such. And now we learn the chairman order in the notices can leave. Next page. Page 66 next page. The proposal for reasonable answer with the requisition is rejected by the Commission of the School Education West Bengal by this memo number such and such on the ground that the provision of Rule 14 to West Bengal Primary Teacher Recruitment Rule 2000 is applicable only to the primary teachers, not applicable to the Group D employees on the higher secondary school. The petitioner number 1, Begum Bahan Ansari, the mother of the petitioner number 2, was not declared properly incapacitated by the medical board constituted for such purpose.
So, this particular year's order, law as operating on the date of
at that point of time.
that is 13th April.
Yes.
2011. So on that date, this 2001 rules was of the
operating.
Then the rule says 14.2.
Yes, but
your argument is that you cannot have dismissed it on the ground of the disorder, applying a law which is not there at the time of application.
This is one of the submissions. Like full submission I have been making.
No, I'm just asking you.
Yes.
They have rejected your claim as per the 2001 rules. So 2001 rules was surely applicable on the date of making the application.
Right. Then, what the rule says? The 457 government order 712
Where is the TSC order? Commissioner of 30th of December 2016, that is not here. It is.
87 memo.
87 memo, Mr. 87 memo.
Yes, that is operating. that was operating at that point of time considerations. It has not been superseded or still that time, that was operating for 27. Appointment of the wards of the teacher and non-teaching employees of the recognized non-government primary, junior, higher secondary school, etc. purpose and norm. Now, the 11 portions will be next page. The undersigned is now directed by order of the governor to say that the government has been pleased to order the section of all previous order in this regard, that the appointment of the compulsion terms of the words of the teachers and non-teaching employees of all recognized non-government education institutions under the director of school education who dies in harness be brought under single umbrella, be given employment from the date of issue of this order in the manner described below. If a primary school teacher dies in harness, the ward of the teacher concerned could be considered for employment in the first instance in a primary school in that district in which the leading teacher last served. Similarly, if a teacher or non-teaching employee of a junior high school has in schools or other education institution under director of school education dies in harness, the ward of the teacher or the non-teaching employees concerned should be considered for employment in the first instance in any junior high or high secondary school in the district who is the disease teacher or disease non-teaching employee last term. Then, if the ward of the primary school teacher who dies in harness not possess the requisite qualifications for appointment as a primary school teacher, or if the ward of the primary school teacher who dies in harness possess the requisite qualifications for appointment as a teacher of a junior or high secondary school and opts for being appointed such, the name of the ward of the either case should be forwarded to the concerned district inspector schools, district inspector as that case may be, before the district inspector of schools secondary education concerned, providing him or her with employment on professional ground, commensurate with his or her qualification. In that case, the name should be placed just below the last name of the roster maintained for the such cases by the district inspector school. Similarly, the ward of the junior high or high secondary school teacher or a school teacher or a teacher of such education institute under the social school education director or non-teaching employee attached to the junior high or high secondary schools or other education institutions under the director school education who dies in harness does not possess what the requisite qualification for appointment as a teacher.
So two options given.
Yes.
Either you can appear here if you don't have the qualification teacher, do an appointment.
Correct. To show the primary teachers, if we have the qualifications, I may be considered.
Yes.
To show merit, I have the qualifications.
You don't have the qualification because you are not a trained candidate.
Trained candidate, my lord,
and your mother was not declared.
Your lordship knows the relaxation was given for the teachers to get themselves trained within the period of 1 year.
That is appointment.
Yes.
One who does not have the training.
Yes. Well, the appointment process, there is no, well, the decisions for giving appointment has already been taken. Now, because with the two orders, past orders for medical fitness,
was he declared physically?
Yes.
But why does the page 66 they say he was not declared permanently incapacitated by the medical board?
Wrong. That is wrong. And my lord, they themselves, that's why I was seeking the.
Mr. Badi, go and file an application before the DIAC and would be vacated. That is
no. That is I am having one of them. Your lordship can page 62, your lordship kindly takes the page 62. I had to approach how long period I will continue. I had to approach thrice before the court for this decision. Your lordship kindly see. First, order of justice starts from page 660, order dated 2012. Thereafter, the medical findings.
Your mother was an employee of secondary school?
Yes. Secondary school.
So why did you apply in the primary?
Secondary school teachers medically incapacitated, declarations, then my appointment, there is a provisions for the primary.
You chose the private
Yes,
school
the private.
as you have a qualification. But that qualification is not fulfilling in terms of Group 2000.
That they have not said so. They are,
We are considering that 2001 rule says training is a required qualification.
that is true. But I can, by the order of the court.
Then after this order, what happened, Mr. Wali?
Now medical findings, page 62.
This is an opinion given. Ultimately, he is
The opinion,
unfit for usual duty
yes, unfit for usual duty.
at present and in future. The
Medical report.
Therefore, next week.
Then my lord, this 2015, the chairman said from the education, other qualities are not eligible for approval of the appointment under diet and harness category as per GO number 160, such and such. So the proposal will not be sent to CSC department. If he wants to join as a non-teaching employee under education department, he may send his option with PPO and family income certificate from the Savarpati of the social Panchayat Committee. Now, again, challenge was thrown. This order was challenged, and just a Boshak person disposed of the repetitions, directing that the rules remaining at the time. There was a date of Supreme Court.
Where is this 25th February 2014 order?
This is the order. This is next, earlier page 63.
That single judge said 25th February 2014 will not be acted.
The 1st April 2015. That is the page 63.
Yes.
Is correct. As the chairman had taken into consideration the government order 25th with
Where is that circular?
February 25, 2014.
There is a
ওরা দেখাতে পারো। The affidavit করো।
Page 66 says that your application will be considered in terms of the rule existing on the your application for what? Application as primary teacher or group D? Primary was group D employee.
But the application is not here, but the
because page 63, that 1st April 2015 order, which you challenged in the page 64 literature,
yes,
that has been rejected by the commissioner, not by the chairman.
Same was challenge. The challenge was thrown, but the page 63.
The court observed that it was rejected by the chairman. No, it was not rejected.
No, chairman communicated the decision.
It was not the decision of the commission, it was the decision of the director.
Page 63, if you understand, he is informed that the educational and other qualifications are not eligible for approval of the appointment under diet and harness category. As per GO number 106, dated such and such proposal will not be sent to the CSC department. That was the chairman says the proposal will not be sent.
Order, my lord. I erect in that
CSC department. If he wants, but chairman has taken a decision that he will not forward before the Commission of School Education. If he wants to join as a non-teaching employee under the education department, may send his own offer.
25th February 2014. Which 25th February cannot be applied. That was the direction of that 20 very good. But on the date of April 13, 2011, the primary rules were subsistent, Mr. Bhatt.
2001. 2001
Which requires for a primary teacher, he has to be a trained candidate.
Malad taxation was there that after appointment that he could get himself trained.
That does not. Where is the 2001?
2001 rule have you brought?
It is
Xerox.
2008 with me, 2001 is not.
আচ্ছা তো,
তুমি এনেছো?
2001.
দেখছো? এটা তোমার পেজ? দিয়ে, দেখো, দেখো।
Da. Now কি বলছে?
Conduct of service
2001. Which provision you are saying, Mr. 2001? 14.2.
14.
Educational qualification as per rules. Possessing required as laid down in A and C of supplement.
The application.
Now you are saying that those who have entered will get time to complete the training.
To obtain training qualifications. Because that is 2001.
That is not in died in harness cases.
The appointment, if I am entitled, my not the case of the proposal and that there. Group D stuff that has been amended, doctor.
In secondary school.
In a secondary school. That is the order is there, secondary school. Why I should make a further application? If I made an application initially, and if I am entitled to have that post of any then my lord, either group D or primary teacher, I could not make a further application.
No, you wanted to be employed as a primary.
Primary.
It was
But-
not your choice to appointed as a group D teacher, though your
But
there was a
rejected, dismissed the writ applications and says that we may have liberty to approach for otherwise.
that is of the 87 circular you are showing.
No, no, well, 1980, this is your lordship can see the rule have given.
Yeah,
amended and-
will you be happy if your application, old application is forwarded to the district inspector of school, secondary education? For consideration of your appointment in any group D post in any secondary school?
But that is the
না, fresh application এর কথা বলা।
fresh application is not required
যে
because
fresh application,
I have been enrolled.
your old application.
Old application I have already been because if the fresh application.
কি চাই ও চেয়েছে তো
No, my lord, the question is that my case has been considered by the office. Either I can be accommodated with a group D or my lord, the primary teachers. Now, if I face applications, then what will happen? I will get the appointment after 10 years because they are maintaining the rosters. This seniority I shall be losing. 2011, which application was made, and the two courts, well, the order, to coordinate bench order is there, not coordinate bench, second judge order is there. I have been considered, it is not the fact. And if your lordship kindly takes up their epidemic, they have forwarded. Your lordship kindly say.
বসে আছে তারা, আগে আছে তাদের কি করে খুশি?
And
So the sense of immediacy diluted.
that is why that judgment Justice Chakraborty delivered sitting with Justice Mandai.
No, it is Supreme Court judge did it. I am saying
that
Devabrata Das decision.
I have not sitting right over the matter. It is not the case that I applied after 14 years. This is a judicial. Yes. This is the one.
2023 Supreme Court.
It is the case, it is a pending, and who considered the matter twice, thrice. Question is the appointment for primary teachers or the group D.
From the very beginning, you went on making application or insisting that the authority to consider your prayer for compassionate appointment to the post of primary teacher.
Because
they stated that you are
not that
you are lacking the requisite qualification.
That means they have said that one after another reason was given. First time no medical is not declared. Third time in spite of declaration of the medical,
actually you lack requisite qualification.
No.
Say that training or anything.
Training. They said that requisite
training.
For training. But there was a
page 66, Mr. Badi. Page 66. After that order at page 64 to be considered in terms of the rules applicable on 17 December. Page 66, pursuant to this order, you file a proposal for appointment to the Commissioner of School Education.
The
Commissioner rejected it by a memo of 30th of December 2016
on the ground.
It is on the ground that provision of 14.2 will not apply.
Yes.
Because you applied to the commissioner for
No, I have not.
CC proposal.
No. This was forwarded by the chairman, Mr. Prime.
That is because you don't have the qualification. As a private teacher.
Court said, your lordship kindly see the court said that you consider the
order is here.
Thereafter, page 66. Page 66. Well, this proposal for appointment Rajikamal Ansari requisition number 2 is rejected by the Commissioner of School Education by member of such and such on the ground The provision of the Rule 42 as per primary teachers recruitment rules 2001 is applicable only to the primary teachers, not applicable to the group D of the higher secondary school. Well, that is wrong. I was suggesting that is wrong. The 457 was operating in the field. And petitioner number Begum Bahar answered.
All right, what is your stand?
My stand is that.
So, but what do you want to say about this July 2015 circular? It over here.
The 87.
Yes, what you are saying?
My lord, asking my lord, the provisions of Rule 42 of the state recruitment rules, my lord, was meant for the primary teachers only. Only for the primary teachers. The chairman district primary school council, my lord, in this particular case, my lord, my submission is that, my lord, applicability of 42 only for the teachers, not for the non-teaching staffs.
In primary, there cannot be any non-teaching staff.
Non-teaching staff.
So,
it is to be that application to be sent to the DI of the DI secretary of the concerned district for disposal of that application or for taking steps in accordance with my law, my lord. They are under their provisions. Secondly, my lord, memo number 457. The memo number 457, just now, my lord, placed before your lordship. Dated, my lord, 12 1987.
14 to primary teacher, not group D. The proposal for of the restriction is rejected by the promotion is rejected.
My lord, this 457. 457.
Yes,
457, my lord, the next page, my lord, clause 2, my lord.
Yes.
The undersigned, now directed by the order of the governor, say that the governor has nor been pleased to order in supersession of all previous orders in this year that the appointment of official words of the teacher or non-teaching staff of all recognized non-government educational institutions who dies in harness. Here, my lord, medically decategorized is not specifically mentioned. My humble submission before your lordships, my lord, that applicability of this memo is, my lord, only for teachers, stroke non-teaching staffs who dies in harness. This memo is not applicable to the employees of group D staffs, my lord, who, my lord, medically decategorized. Here, my lord, it is basically written, my lord, that dies in harness. So therefore, and under the rule, my lord, Rule 20, Section 20 and 21 of the West Bengal School Service Commission, my lord, selection of persons for appointment of yearly, my lord, provisions are there for their employment. And my lord, moreover, this application was made paying for appointment to the post of a teaching assistant teacher of the district under the district primary school council. My lord, this particular application on the earlier occasion, when it made, my lord, that application was made for appointment to the post of primary teachers, not for the post of group D staffs or whatever. Since and he has, my lord, according to in the said application, he also, my lord, stated that he has requisite qualification. Therefore, my lord, the rules specifically there and there is provision under the, my lord,
No, after the court's order
Lordship.
passed in WP 5832, you passed this order, which you have annexed
Lordship.
in your affidavit.
Yes, in the affidavit, my lord, I have annexed 2 orders, my lord.
What you are saying?
Supplementary affidavit you have annexed the order of the chairman,
Of the direct.
order of the commissioner. You have not said so.
No,
This
supplementary.
order needs to be looked into.
My lord, it is the affidavit in opposition, wherein, my lord, I have annexed.
Annex both.
But it was not, my lord.
No. We need it. We need it.
Your lordship jumped in. That you should not use that, not take into consideration the supplementary affidavit because it was not filed before the date.
No.
I kept.
At that time, you said only the affidavit affirmed by affidavit affirmed by the council, not used, not placed before the court. But the order of the chairman and order of the commissioner may have relevance.
Yes.
That is the affidavit.
Consider.
Yes, your lordship can consider. Because when your lordship was given, your lordship can consider everything.
Notification I could see. People wrote me 14 to April. 14 of কিছু বললো ওরে বললো আমি সেন্ডিং কমিশন এবার কমিশন বলবো যেহেতু টিচার প্রপোজালটা পাঠান The process is considered when no relief can be given. যেহেতু his mother was a good staff, employee of higher secondary. এটা তো ভুল করেছে কনসিডার করো সেকেন্ডারি এখন ও বলছে যাবো কেন এই অর্ডারটা this 30th December 2016 order has now been challenged in the present. You have challenged the order of 30th December 2016 in this present resolution.
Yes. No, এটা দেয়
No.
Let me
Chairman.
No, I have no
challenge. Chairman.
That is only the chairman. This first time disclosed by the so there was
So by this order, it was forwarded to the commission.
Right.
So
And now there is a judgment is in place before your lordship, the coordinate bench, division bench. presided over by Justice Calcutta. The very interesting, one of the chairmen, when the proposal by the chairman was submitted before the Commissioner of School Education, the question arose whether the Commissioner of School Education has authority to reject it. Fact-finding authority is the chairman. District Primary School Council is the forwarded to. Before the division bench said he has no authority to reject or he has no authority to reject. Because fact-finding authority came to the conclusion and forwarded for approval. His only question is only to other qualifications and required qualifications. These are required to be checked. You cannot reject the proposal which has been submitted by the district primary school councils. That should have the authority. You know, I'm extremely sorry that the what we acting between the charge and
চেয়ারম্যান এর টোটাল চ্যালেঞ্জ করে চেয়ারম্যান পাঠাবো ডিরেক্টর ডিরেক্টর যে ওর অ্যাপ্লিকেশনটা ওটি একটু রাইডারটা রাইড হওয়াটা যখন গ্রুপ ডি হিসাবে বসে একটু চেয়ারম্যানের কাছে চেয়ারম্যানের কাছে অ্যাপ্রুভ করে as a primary teacher. So in this case, new order may not be applied. Also, this is so necessary because may be sent to a commissioner. 41 primary teachers. What did you challenge in the read petition?
The
chairman order.
Order of the chairman.
The chairman forwarded it to the commissioner.
It appears from the read petition.
You have brought the read petition on record.
Yes, yes.
Read petition is
Yes,
here.
yes, yes. Page 66 by check. Because it was not disclosed by the first time my letter was disclosed it to the availability.
It was communicated to you. What you are saying?
No, no, my lord, don't communicate.
This order was not communicated.
No.
What
let him, my lord, the 30th December 2016.
আমি ওইটা কথা গেল যে 66টা পরে yes and this was in form page 66
yes
page 66 just inform whether order was attached there to or not under this memo
my client is not so cool that he will not challenge it. This is the only communication made by the chairman, District Primary School Council.
Yes.
The communication proposal for appointment rejected by the Commissioner of School Education West Bengal. It is applicable only to the primary. The mother of the was not declared.
In the read petition, where did you take that ground that there was no communication of this 30th December order? In the read petition, have you stated, Mr. Vadi?
Let me check.
This is your annexure.
Right.
Whether order was annexed or not, you should have asked them to produce that order before that court. And by filing supplementary affidavit, you could have challenged it.
Well, had it been communicated first time, had it been
communicated? No, it was informed. You are informed. Whether order was attached with this covering letter or not.
Well, I have been communicated the order the letter of 16 February 2017.
That letter says that your case has been rejected by 30th December.
That is the first time I came to know from the
everything, Mr. Badi, if you say that I don't have this, it was your statement, your annex.
I have said so.
Not a line you have argued. that this order I have not seen this order has not seen the light of the day.
First time, if it is.
30th of December 2016, 2017 memo, you will not say, where is this order?
That was not.
And before us, you are citing Justice Talukdar's order, wherein there was not that sort of a situation. Here, you yourself, getting the memo of 16th February, you came to know that your case has been rejected on 30th December.
We have not categorically mentioned this. First time it is.
How can we appreciate this, Mr. Badi?
No, I follow your lordship too. But Melody, I tell you lordship.
This was your junior. The person who was drafting was never aware of this.
Again, I am repeating my submissions.
If I say, look, Justice Chakraborty has rejected your prayer, white order dated as such and such date, you will not ask me, so Justice Chakraborty's order, or hand over the same. Because I have not rejected.
It is better.
I have just communicated this information.
I have met my submission. It is better not to. I submit that is maybe mistake on the part of my client, but it is a fact it was not communicated. Let him show the single document. They have communicated this order to my
order, yes.
Let him show the single document. They have communicated.
Now you have submitted affidavit in opposition to the
nothing on the motion.
No, to the application for stay.
Proceed. No, Mr. Saha. We will record your statement. The original copy is here. It was supplied to you. You are not disputing that.
No, there was my lord. I said
so. As Mr. Badi has brought that on record by the supplementary evidence.
That was submitted by me.
No, that was submitted by Mr. Badi.
Badi, yes.
Enclosing the copy which you have given. The opposition.
My lord, the opposition I have already, my lord.
That is what I am saying. As you have given the copy, he has brought it on record. We will keep the original on record. And we will give you an opportunity to deal with the allegation. As regards communication and everything, if you want to say, you say.
But although by an order dated 10th December 2025, we requested both the parties to avail instruction whether the affidavit in opposition
দামটা দিচ্ছিস তো? হ্যাঁ, আমি হোয়াটসঅ্যাপ এতে আছি।
first week of March.
Yes. First week of March.
Fifth month. Fifth month.
Fifth month.
First week, no, you are wanting. You are wanting. Fifth March.
Item number 22.
I appear from the application. I attend Malan. Typical is today morning, learned advocate general print. Updated something Malan today is not after 12, will not be available.
You proceed.
Now, what are the earlier direction you were standing up?
That I have communicated with him.
No, what can be done, Mr. To tell us?
One chance.
To tell us.
Yes, that last occasion was this.
If your advocate general has to appear in all matters, it becomes embarrassing for us. We usually do not shut out people. We allowed 3 chances. We recorded in the order. But still, if you cannot bring the advocate general, you argue.
Today,
If we give you adjournment, he will be thinking bad of us. Court does not, court gave order, now court is against. Then it becomes embarrassment for us.
I also told him that just before 2, I had a talk.
Last chance was given.
Yes, that also I have from the order also. One more chance.
Tomorrow it will be there.
And
Tomorrow, come tomorrow you will do. Tomorrow you will do.
Don't take time for Mr. Tomorrow. If it is reached, you do. What issue?
The issue of this present appeal.
Higher scale.
No, is this re-employed teacher, whether they are entitled to get the revised pay scale?
Revised pay scale, maximum was given. Some of the portion was due or directed to pay. It has not been paid. Calcutta University employees moved to repetitions and thereafter appeal court decided the issue. And for Rabat, with the Calcutta University, that's why
you are in which university?
Jalur.
In Jadavpur, it has not been.
And court, while granting a stay order, then my lord asked the Jadavpur University, asked the state authorities to deposit the amount. They are about 40 lakhs. 1 crore. 1 crore.
At the time of stay.
At the time of stay, conditional stay. Then you deposit it. Because
now your clients are still working.
No, they have retired. They have some of the clients.
Mr. Gupta, you show us the judgment now. You start.
So you give the copy or give the reference.
Yes.
Give the copy, possible. Give a copy. You go through the judgment and.
Tomorrow you will come and say, I've been given a copy today, I have to take instruction.
That's what I have.
Yeah, I just you know,
Yes, next.
23.
23.
What about Mr. Mitro? Any solution?
Kindly pass the order on me.
I see. It would be finished also. So now no settlement can be reached as regard. So we will deliver our case. Difficult.